Item 2.
To be called again. Item 2, you are there. File ta. Memo file korchunti, you are not taking the responsibility even. I trust you and accept the memo, then you are not. Memo da kain?
Memo mention.
Again. Apno memo deleni.
Sir, aji de debi.
Apno aji bhi fer ko kali rakhibi. Apno.
Sir, aji.
Not do it. And you are looking at me as if I am saying something very unusual. You see, this cannot be the indulgence shown by any court. Today you should have been ready with the memo. Still you are seeking time. Yes, next.
Item 3.
Madam, you mentioned that I'll give the details. You have not mentioned in the memo nothing. The petitioner has been acquitted. I am not accepting that kind of submission.
Sir, actually, advocate is suffering from heart problem.
After the memo was accepted or after
the memo.
Now, how it is related to the number, knowing how if he informs you, the advocate informs you who has suffered heart problem.
The opposite party.
Sorry?
The advocate from
Lower court.
Yes, sir.
Na High Court advocate.
Lower court, sir.
Jodi tanga heart problem hela, upon tanga outhra kon heart attack diya karuchundi kainki. You have to be careful about the advocate.
Sir, as per instruction, kindly consider the matter as not fresh.
No. I cannot take the matter as dictated by some advocate who is having heart problem. I also have a heart, madam, heart, brain, and by God's grace, there are no issues there. I can't take the excuse of me having some health issues and all that. No. Item 3 lekhantu. Apan ko na bhi de nahanti.
Sir, Suman Mitra.
Apan ko power nahi kemti de dele.
Sir, on behalf of Mr. P.K. Naik.
Simti apan simti karantu ni. You are taking too much of risk.
Sir, my senior is arguing on another matter.
Apan to sunibe nahi aao. You are not listening. Nobody is inviting your senior. Without being authorized, without having power, you are withdrawing a petition. On behalf of Mr. P.K. Prasanta Kumar Naik for the petitioner, Mr. Standing Counsel for the State. Apan kali kon kahithile? Mention kala bele kon kahile?
Sir, accused already acquitted.
Acquitted. Lekhile kon memo padhile. By flux of time, the case is infructuous. The petitioner has been acquitted. Acquitted spelling bhul gala. Leave that habit. What a bond korthile jo korchanti to? Simply jaha lekhibe the court, he cannot attend the court. On aji ket tarikh?
23rd.
On 22/11/2023, it was the matter was in the list and it was mentioned by the learned proxy counsel. On 17/11, I'm sorry, on 17/11 the matter was in the list and it was mentioned by the learned proxy counsel that the petitioner has already been acquitted in the pending proceeding. That is pending before Additional Sessions Judge Titlagarh in S.C. case number 74 of 2014. The learned counsel for the petitioner, the proxy counsel, the learned proxy counsel was requested to give the details of such order of acquittal while filing the memo. The memo dated 17/11/2023, signed by the learned proxy counsel, indicates that does not give any details of the orders of acquittal, like the date, case number, etc. Para. The matter was again listed today for ascertaining those details. The learned proxy counsel submits that her senior is busy in another court. It is further submitted that the instructing counsel who was handling the matter in the lower court, the learned instructing counsel was handling the lower court, is suffering from heart ailment and is unable to provide any details. Para. In view of the above, the registry shall obtain the present status of the matter from the additional session judge Titlagarh in SC case number 74 of 2014. अपन जो additional Titlagarh लिख लें Titlagarh session judge oblique लिख दें तो the court and season of the matter. List on आज के 23 list on 2 weeks पर 23 list on 7 कि 11 कर दो. Yes, please. Next, Mr. Acharya.
My lord, in this case, I seek for an adjournment because I don't have the copy of the.
Mr. Standing Counsel for the State, the Lord Counsel for the Petitioner seeks adjournment to advance.
Let it be admitted. I prima it has come for admission. Let it be
Sir, I am not admitting without hearing, sir. Sir,
All
please point out why it is to be admitted. The learned counsel for the petitioner submits that the matter be admitted without addressing any arguments. The such prayer is
regarding admission, may I submit my lord?
granted further opportunity to advance arguments.
It may be listed in the second week.
I think I informed your learned junior also because
No,
he
no,
may admit this.
No, not in this case. Another case.
Exactly. So I think, but in all cases, I think to my limited understanding, I have to hear and understand before admitting.
If your lordship, I will address on the question of admission.
No, I have already passed the order. I have rejected your prayer for admission without addressing.
All right, my lord. I pray, my lord, let it be on the second week of January, because I have.
The learned counsel for the petitioner, though the matter is pending since 2011, and is yet to be admitted. The learned counsel for the petitioner seeks accommodation till second week of January. Though this court is not inclined to grant any such adjournment in view of the pendency of 12 years. But the learned counsel has persuaded to adjourn the matter. The matter may be listed when moved by the learned counsel for the petitioner.
Item 5.
Bail order recall कर देले छबो.
Sir, I don't have the copy of the deposition.
When the learned counsel was for the petitioner,
I don't have the copy. I have
found that the petitioner is enjoying bail as granted by order dated 25/11/2011 in Miss Case number 1190 of 2011. And in view of the repeated adjournments, that the bail order should be recalled. The learned counsel submits that it doesn't have the case brief. Yes.
Item 5.
My lord, item 5 on behalf of Mr. R. Acharya. Matter has been,
Sir, I am still at the matter of Mr. Acharya. First Acharya, then Acharya. Yes, we are enjoying bail and stay of the bail and stay of the recovery of fine.
Yes, my lord, what I beg to submit, my lord, in this case, except the memo of appeal and judgment, I don't have the copy of the deposition.
Right, sir. I have already indicated that you have not done.
Yes.
You do not have
So
the
that is
esprit,
the
so
reason I required your lordship a fixed date after into vacation, that is second week. I will address if the materials are available or if it is not available.
I'm sure, sir, you are listening to me, sir. I have already
Yes.
passed those orders, sir.
Yes, your lordship. I am
If
obliged.
I will again dictate those orders, then
No.
I don't know what the bar will think about me.
No. Your lordship.
If I repeat the order again
No.
and again in one page, I have already passed those orders, sir.
I am obliged that your lordship has.
I am also grateful that you are repeating your submission even after passing the orders again and again. I am really grateful.
I will do it. Well,
I don't know what bar will think about me. Today we have started with heart element
No.
of a lawyer.
No, I have not started with that.
We.
Oh, yes.
Definitely not. You are at safe distance at your comforts of your home. Yes.
Obliged.
Item 5,
My lord, item 5 on behalf of Mr. R. Achari.
Your name, sir?
Status
D.
report, your
Patnaik.
lordship.
Mr. D. Puranada, Debabrata.
Darpa Narayana Patnaik.
Mr. Darpan Narayan Patnaik on behalf of R. Achari.
Matter has become infructuous.
The counsel for the petitioner.
He is saying that it is
It
infructuous.
has become infructuous, my lord. In the meantime, petitioner has got convicted and
The learned counsel for the learned proxy counsel on behalf of the petitioner submits that the matter has been rendered infructuous. Why, sir?
Convicted in the
he has become he has been convicted and has preferred an appeal.
That date ta kebe ki joda flaw chi status report ta kondhamalu aschi date ta jani honi. It must be older one, not
My lord.
2016. The petitioner has been convicted by order dated.
Sorry, my lord.
Order dated, sorry. Who calendar se tagi? Court. Upon revision cognizance challenge korthile.
My lord.
against rejection of
Discharge
discharge.
order.
person.
Discharge it.
Yes.
As the challenge was to the order dated 2010-2023, rejecting the petition of petition praying for discharge filed under section 245 into bracket 2 of CRPC in by the learned JMFC G. Udayagiri in GR number 106 of 1993. In such view of the matter, nothing survives for adjudication in the present petition. The petition stands disposed of. Yes.
Obliged.
Yes, please.
item 6,
Madam, I'm sorry, your name, madam?
Sangeeta Mahanti.
Miss M.S. Sangeeta Mahanti. Sangeeta Mahanti on behalf of M.S. D. Mahapatra. The petitioner, Mr. S.S. Mr. Standing Counsel for the State, Counsel for the petitioner, 6 adjournment
2 weeks.
to advance arguments. After vacation,
Again,
आज spread for list on 8th of January 2023.
Copy may be served.
obliged.
The learned Standing Counsel requests for a copy of the petition to be served. But copy nahi.
Again,
Let the copy be served within 7 days. Sufficient time you take.
obliged.
पुणे जो नुआ कैलेंडर ता ड्राफ्ट गाणी रखी नांती गोटे जेरस कर दियंतु समस्त देथिवा कथा आपण मेन लोगों को दो नांती कैलेंडर.
item 7,
Seven to be called again.
7 is also infructuous. I've checked it. Although I don't have the copy, my lord.
7 infructuous.
Yes, my lord. Challenging the show cause notice issued in 110, my lord, proceeding. And in the meantime, my lord, that has been, my lord, actually that has stayed. But that 110 proceeding is, my lord, is for, my lord, if the bond is giving, my lord, that is for 3 years. It's a 2014, my lord. Whatever it may be, my lord, it is infructuous in that.
we can wait since we are
Yes, yes.
passing it.
I don't have the brief, my lord. For my lord's view.
Seven just pass over to be called again. Yes.
Item 8,
My lord, 8, my lord, we have filed the criminal leave petition, my lord. Here, my
Yes.
lord, fairly speaking, my lord, yes, lords.
Notice issue है नहीं आगुरु notice है नहीं तो
No, my lord.
जोड़ा आगुरु notice है चीज़ जोड़ा रहुची
Yes, my lord.
जोड़ा first time पे आसिला ना किची है नहीं
I
You are
checked
right.
it, my lord. You are
किची
right.
deposition
No, my
copy है
lord.
क्या अच्छी
Yes, my lord.
deposition copy अच्छी
Yes, my lord. That I have also.
you are having eye infection
My lord,
something some foreign particle
Okay. My lord, here, my lord.
IA 62 of
My lord,
2019
that has been wrongly tagged. That belongs to some other case. I have to check it from my lord's file. My lord, that has been wrongly
State
tagged.
versus Kondapalli Chinna Rao
That belongs to some vigilance case. Actually, this case belongs to 341, 323 SST Act. My lord. That
the
2019.
IA 62 of 2000 then it has to be listed again. This is 2019 na?
Yes.
The IA 62 of 2019 that has been tagged to the present case arises out of CRL LP number 77 of 2019,
Yes.
whereas the present case is the present petition is CRL LP 77 of 2018. The registry shall detag the IA 62 of 2019, tag it with the correct brief, correct petition, that is CRL, after verifying the same, after verification, the IA arising out of the present CRL LP, upon number ta achhi ki?
I don't have the, my lord,
Brief nahi.
we don't have a delay, my lord. It has been filed in time. That is the.
It is acha gala se para sorry gala ta after verification then sub para as per the stamp report
No defect.
there is no delay in filing the
no.
present CRL LP. Accordingly, the petition is taken upon merits.
Here, my lord,
The learned standing counsel strenuously argued that the petition, in view of the grounds stated in the petition, it is a fit case where leave should be granted to appeal. However, it is also fairly stated that apart from the evidence adduced before the learned trial court and the materials presented by the prosecution, no further material can be considered as far as considering as far as while considering the prayer for grant of leave to appeal. Yes, Mr.
Yes,
ଆପଣଙ୍କର star witness କାହାକୁ present କରିଥିଲେ?
my lord, actually, PW1 is the, my lord, the informant actually.
Okay,
And there are
PW1.
actually 4 eyewitnesses there. 3 eyewitnesses. Out of that, my lord, 1 has been examined, my lord, as PW2, and he has turned hostile. That Pavitra, my lord, may kindly see the depositions are there, my lord. That he turned hostile. At the statement of PW4, the IO, my lord, that, my lord, says that prior to that there was a, my lord, discussion, and my lord, and they both went to a temple for, my lord, having my lord, settlement, but those things are not there. Since those things are not there, my lord, the entire episode, my lord, goes.
The कौन लिख ले? So could last line ta? This court has occasion to go through the copy of the judgment passed by the learned court of the first instance. It is noticed that it is found that the learned court has dealt with the evidence presented by the prosecution. The PW1 in his deposition has not disclosed about the accused opposite party restraining PW1 from proceeding in a direction to which he has right to proceed. nor it discloses that the opposite party accused, the opposite party caused annoyance to anybody by uttering any abusive words, the IO in his statement regarding the IO in his examination, the IO in his deposition before the court was confronted with the statement of the PW1, and the defense brought out the fact in the statement of the IO that he has not recorded any statement of the PW1 regarding use of offensive language. IO is PW4, na?
4 years.
IO bracketed PW4. The IO further deposed that he did not investigate regarding the report regarding enmity between the accused and the informant. That is, he did not investigate regarding the mens rea on part of the PW1. I'm sorry, on behalf of the opposite party, to offend PW1. Stop. The IO also, the PW4 also has stated in his deposition that he did not ascertain the cause of delay in lodging of FIR by the informant PW1. In such view of the matter, and in view of the above discussions, in considered opinion of this court, the case is not the present case is not fit where leave can be granted to appeal. Beginning paragraph ta likhibe. The CRLLP has been filed under the provisions of so and so CRPC 371, 378 into bracket 1 and 3 of the CR.PC 1973, seeking leave to appeal against the order of acquittal dated 27.02.2018, passed by the Learned Special Judge Sessions Judge Kendrapada in ST case number 13 of 2016. Pura first parata dekhi likhibe ta pore eta continue kar. Arising out of M.S.Sahoo PS number so and so, corresponding to GR case number so and so, acquitting the opposite party from the charges under section so and so. Yes, next.
Item 9.
Please, Your Lordship.
2018
In
matter.
the matter of admission, let notice go or let other party appears. So can
It's fresh na nahi ye.
It's a fresh case, Lords.
18 matter arjo nahi ki thau. 18 matter tame no le na. Old matters we are taking.
Agreed, Lords.
Because I think apna 18 uda ka joda thila.
Exactly. We are focusing on the old matters from 14 backwards.
The Learned Standing Council appearance likhibe, Standing Council vigilance. The Learned Council advanced after advancing certain arguments, seeks further accommodation to advance further arguments. As prayed for list January ko nahi janta. Third week adugu. List on 24
Item 10.
10, Mr. Sahoo.
Yes,
Mr. D. Sahoo.
yes. I pray taken up next week file is misplaced somewhere. So play
The Learned Counsel for the petitioner submits that the case brief has been misplaced and he may be accommodated to retrieve the same. As prayed for, list on
No, no.
9th of January. 11.
11.
Item 11, the petition or challenge
You are Mr. Naik.
ଅଧିକାରୀ ଚିତ୍ତରଞ୍ଜନ ଦାସ
ଆଚ୍ଛା ଆପଣଙ୍କର ଆର ମ୍ୟାଟରରେ ଯୋଉଟା ଜଣେ ଇଏ ଫ୍ରେଶ ଇଏ ପ୍ରାକ୍ଟିସ କରୁଛନ୍ତି ପବିତ୍ର କୁମାର ନାୟକଙ୍କର
ଆଜ୍ଞା
ତାଙ୍କର ପାୱାର ନାହିଁ ଆପଣ କେମିତି ତାଙ୍କୁ ଗୋଟେ ଦସ୍ତଖତ କରେଇକି କରିଦେଲେ ମେମୋଟା ୱିଡ୍ରଆଲ ପାଇଁ
That is Prashant Kumar Naik.
ପ୍ରଶାନ୍ତ ଇଏ ହେଲେ
Pavitra.
ପବିତ୍ର ଅଛି ଠିକ ଅଛି
ଆମର ନୁହଁ
ଭେରି ସିମିଲାର ଅଧିକାରୀ ଚିତ୍ତରଞ୍ଜନ ଦାସ ଫର ଦ ପିଟିସନର yes Mr.
When the petitioner challenged the judgment dated 19/11/2020 passed in criminal appeal number 12/2020,
Yes.
executing the accused to the appellant in set aside the order that in 138 NI Act 1 CC number 193/2018.
Yes.
The leave petition is filed for the leave petition is filed for permitting the petitioner to
Yes,
file the appeal.
yes. Where is the perversity or what is the best point in your case? Seta kuhuntu state. Obviously, you are not satisfied with the judgment, but what is the best point in your favor? Where the learned appellate court erred in setting aside the order of conviction.
The order of
And
conviction.
please, 138 is a technical offense. It is more technical than, apart from the attending facts, more technical. Because the ingredients very specifically mentioned in 138 and other notice or everything has to be satisfied. You see the judgments dealing with those matters. Upon para 9 dekhile? Para 9 internal page 5.
Para 9 of the judgment, my lord.
Again. Internal page 5, para 9. The last paragraph in internal page 5. Running page 31.
My lord. On a hearing of the parties, the appeal, the parties are
Not a page missing or chimo page. That's a problem.
page 31.
Physical file ta dele? अच्छा ठीक अछि सेटा तळ ऊपर कर दैछन्ती बुझ पाले 30 परे कर दैछन्ती 30 32 देन 31 हां ठीक अछि पढंतु अछि से फिजिकल फाइल भी अछि ठीक अछि
Page 31.
पारा 9 देखंतु बाइले पर आपण फेर ताकू भी आपण
Again. On a hearing of the parties, the appeal the points that arises to determine in the present appeal are whether there
points
was a
that arise actually so arises भूल लिखे anyway ठीक अछि points that arise for determination in the present appeal are whether
there was a existence of a debt liability for the discharge of which the check is question was issued, whether the absence of a sale or a signature over the bank slip exists exhibit 4
ଟିକେ ବଡ
and
ପାଟି
5.
ସ୍ପଷ୍ଟ ପଢନ୍ତୁ ସାର୍ ନହେଲେ ମତ ଯଦି କହେ ମୁଁ ପଢିବି ଆଉ କଣ କରେ କିଛି ଅସୁବିଧା ନାହିଁ I have no problem
Whether
ସ୍ପଷ୍ଟ
the
ପଢୁନାହାନ୍ତି whether in absence of seal and signature over the bank slips exhibits 4 and 5 the learned trial court could have drawn the presumption as provided under section 146 of the NI Act
My lord.
whether the judgment of the learned trial court is liable to be interfered with. So now you have to show. Have you challenged that finding? Apanakara ground re exhibit regarding exhibit 4 and 5 that there is no seal and signature of bank.
My lord.
Have you challenged that finding in the first of all whether you have challenged? If you have not challenged, then there is no point in here deliberating both of you and addressing me and me deliberating with you. Challenge करचंती कि से exhibit 4-5 ऊपर
आगे आगे
को ground रे नेचन देखान
exhibit 4 and 5 रे कहउछन जे सिग्नेचर टा करि नांदी बिली
signature टा नुह
seal बैंक रो seal
seal and signature signature टा करनांती बोली नाही
seal
exhibit 4 रो आपनकर it's a bank stationery
Right.
it is available everywhere so that is so sei jinsa ta apana sei issue ta authore apana itse argue କରୁଛନ୍ତି ki because it's a question finding of fact because did you mark the issue the learned appellate court has said the finding given by the learned trial court is no seal and signature but a presumption can be drawn 146 presumption so that's a concurrent finding of fact by both the courts so maybe that is the reason आपण किंतु कहले challenge करचंती बोली सितमे मत देखांतु because से आपनकर revision रे I cannot set aside concurrent finding of fact interfere also if you then suppose now it can be a question of law since it's a mixed question of fact and law it can be a question of law that even without seal and signature of the bank if that is relied on upon you have relied the complainant has relied on the seal the 4 and 5 bank slip so bank slip whether can be relied on without seal and signature that may be a question of law so seta nale dekhantu law anantu dekhantu the ground niche ni kodi dekhantu first of all
page 10 E ground E
पढुनांती
that the mere non-availability of any seal or signature on the bank's return memo sent through the registered post whether envelope has been exhibited by the exhibit 6
4-5 sir 4-5
disbelieving it is not sustainable in the eyes of law.
4-5 कोड नीचे टिके मन रखिबे ना हमर this profession has this multitasking is the charm of this profession हमें आरंभ करले 4-5 आपण 6 पढिले don't do that
that the opposite party has admitted that he has received the demand notice and in reply to the notice he has admitted that he has issued the check and admitted that there is a liability but disbelieving the existence of 4 and 5 is not accordance with the law
disbelieving 4 and 5 disbelieve तो किसी करना है 4 and 5 पर मार्क ହେଇची
आज्ञा
और disbelieve कौन करी implication of 4 and 5 disbelieve no one is that's not a question that 4 and 5 has not been admitted I don't know maybe admitted with objection but that 4 and 5 is not disbelieved आपण admit आपनकर केस हैला 4 and 5 रे स्टार सील सिग्नेचर नाही
आज्ञा
so what is the implication disbelieve करा है नहीं 4 and 5 disbelieve कोठी करा जाए what is the meaning of disbelieve not believing means seal is there signature is there but it is not believed to be the seal and signature your case is that there is no seal and signature as such so that trial court can be deal करचंती देखंतु then you will get a hint
बैंक रो फॉल्ट है सेटा सील मान there must be an existence of a liability the gold loan
so let us not jump from one issue to another
okay
appellate court gote issue frame kale
okay
that we have to see that whether they correctly framed the issue first of all and it's a concurrent finding of fact. Yes. Kota sheda trial court kuta deal korchanti 4-5 ku. 4 and 5 have been marked as exhibit by you or by the defense.
Defense
Mr. Das.
on 16.
Exhibit 4 and 5 by defense.
Defense.
Habani 1 2 habani. Defense exhibit guda 1 2 3 4 hueni.
16 on mere aspect
देखो आपण ट्रायल कोर्ट जजमेंट को जानतु
Complainant.
पेज 20
2020.
पेज 20 पारा 11 को पढन्तु
Accused them nil. Defense or nil. No.
सॉरी आपनकर वॉइस ता टिके टिके आस करने तळे रहि जायछि त
Defense nil. Document, no document.
नहीं ठीक अछि पारा 11 देखंतु रनिंग पेज 20 इंटरनल पेज 8 of the judgment. But muted reading करंतुनी. That's a difficulty. In a courtroom interaction, if the
so
lawyer
far as-
goes
so far as
muted,
the-
though, then
so far as the present
the
case is-
second point for determination, para 11 starts the second point for determination.
the second point for determination in this case is as to whether the check was drawn by
Check
accused,
so drawn,
check
check
so
so
drawn
drawn.
by accused was returned
return unpaid
unpaid
when presented.
when-
Yes,
presented by the complainant for enhancement within
encashment,
the encashment within
encashment.
the period of its validity.
validity.
This regard, it is the evidence of the complainant that he deposited the said check marked as Exhibit 1 and Exhibit 1A with his banker SBI,
It is
Jalda
it is slowly
branch.
iti padantu. With his banker SBI
banker SBI
Jalda.
Jalda branch,
Jalda branch Rourkela for
Rourkela
collection.
collection.
But the same was dishonored due to funds insufficient in the account of the accused. The complainant has proved the check return memo SBI Exhibit 4 and Exhibit 5.
Due to insufficient effort in
Yes.
accordance with the of the accused, which was ultimately communicated to him through registered post by the banker, and the said registered envelope marked as Exhibit 6 by the complainant. But the law and defense counsel,
ସେଠି ଅଟକନ୍ତୁ ଆପଣ
ଆଜ୍ଞା।
ଆମେ ତ 4 5 ଟା ଫେର ଦେଖୁ ଆମେ ଏକ୍ସାମିନ କରୁଛେ 4 and 5.
ଆଜ୍ଞା।
So what is Exhibit 4 and 5? Check return memo
Okay.
sent by registered post by the bank to the complainant
complainant.
in a registered letter with cover Exhibit 6. And interestingly, Exhibit 4 and 5 do not contain any seal and signature of bank. ଆପଣ ଏକ୍ସାମିନ କରିଥିଲେ 4 and 5. The problem is that ଆପଣ କଣ ଆଉ ଗୋଟେ ଡିଫିକଲ୍ଟ ହେଇଗଲା ଆପଣ 4 and 5 କୁ ଯେମିତି ଆପଣ ଯେମିତି ମାର୍କ କରନ୍ତୁ Exhibit 1 or 1A. Exhibit 1 is the check, 1A ହେଉଛି signature. 4 and 5 କୁ ଆପଣ ପ୍ରୁଭ କରିବା କଥା ପ୍ରୁଭ କରିଛନ୍ତି 4 and 5 କାରଣ କିଛି ନାହିଁ ତା ଦେହରେ. I don't know how the learned trial court accepted that and without proof. It is marked as exhibit, but it has to be proved. Your basis of your entire check return memo, is the entire basis of this case. To start with, I was thinking that the registered letter was a notice actually. But the bank has sent it by registered post with AD with a registered cover 6. So how the trial court accepted that? Even the major challenge, major risk is that bank stationery is printed locally. It's not centrally procured. Whatever you are filling up, or they are using for their internal thing. But anyway, because 138 ପାଇଁ ସେ ଆପଣଙ୍କର ବ୍ୟାଙ୍କ ଆପଣ ରିଟର୍ନ କଲେ ଯୋଉ ରିଟର୍ନ କଲେ ଆପଣଙ୍କୁ କିଛି କାଗଜ ଦେଲେନି चेक रिटर्न किए करे to just think it differently. Your banker, the person who has returned the check, he has not put neither put seal or nor signature. Deposit is proved. Issue is also proved. If it is return is not proved, आपण केमती कहबे 138 satisfy होला बोली
सेटा बैंक रो फॉल्ट
could be. Kahara fault, we are not on a fault finding mission. We are assessing evidence presented before a court.
complainant suffer होइयो ना
You see, in any case, there can be a better evidence. That's not so. What that cannot be. And you should have maybe, but mu jani ni eta ko kahi ki se tangu daki nahanti because there was nothing. Nal tangu examine kariya katha. You should have adduced evidence.
examiner दवा katha
That it was sent by the bank. Then the problem is that anyone can send a registered letter from bank to any person, any account holder, by putting a slip that it has been dishonored. Then how do you prove the not even upon the beyond reasonable doubt to habani preponderance of probabilities re bhi habani.
permitted
देखो टिके पढ़ंतु तापरे हम जाई नथिले बट आई थिंक वी आर ऑन द राइट ट्रैक टिके पढ़ंतु जलदा ब्रांच राउरकेला exhibit 4 and 5 due to insufficient funds in the account of the accused which was ultimately communicated to him through registered post by banker तापरे पढ़ंतु and the said registered envelope as exhibit 6 by the complainant.
But the defense counsel strongly objected on the genuineness of the exhibit 4 and exhibit 5 as there is no seal and signature of the branch manager of the concerned bank. The objection of the accused was countered by learned counsel for the complainant saying that the said memos are being prepared digitally and accused may call for the branch manager for the concerned bank to disprove the exhibit 4 and 5. But on the verification of the exhibit 4 and 5, there is not mentioned that
it is
said memos are prepared digitally and not required the sign and the seal of the banker.
पढ़ंतु
It is the duty of the complainant to prove its documents beyond all reasonable doubts by calling the branch manager of the concerned bank. But in this case, the complainant has not shown any interest in this regard.
So that means that is how actually the Lord trial court has also rejected that. I don't know how they could return the finding. But appeal जो issue frame करना है second जोड़ा अपन पढ़िले appellate court रो. Precisely the appellate court's issue is same frame because appellate court also noticed that the Lord trial court has accepted the exhibit 4 and 5 not being signed or not being issued. आपनकर आर्गुमेंट हला जे सी प्रूव करियो डाकिए ब्रांच मैनेजर सेकंड व्हिच इज कंप्लीटली कंट्रारी टू लॉ सेकंड एस्पेक्ट हला जे सेटा आसिला डिजिटली सही नथिला बट कोर्ट गिव्स ए फाइंडिंग दैट देयर इज नथिंग डिजिटल and this is not digital in fact in any event this cannot be digital. Digital ta is a interbank transaction not a communication to a person who is holding an account. तापरे पढ़ंतु in the case at hand सपरा in the case at hand पाइले the fact of the exhibit 4 and 5 have been disproved by the accused that the said memos are not signed or sealed by the banker.
But there is
proved बोली भी कहले but there was sufficient opportunity in the hand of the accused when he replied on demand notice. तार को relevance अछि. Yes, what do you say? कौन कहउथिले गोटे
लीव
फर्दर टाइम
नहीं लीव टा अलाउ कर दले हम ग्राउंड नहीं जानतो सही ग्राउंड रा अपील रे remand କରିଦେଲେ ବି appeal ରେ ଆଉ ଥରେ try କଲେ
most illegal and unethical order that would be. Most illegal and unethical.
I'll take the time.
I myself I am not satisfied. You are not satisfied. The court is not satisfied. But I will grant leave. You will take the ground. What ground you can take? It's not a fit case. যদি সেটা কিছু অছি সেমতি কেস ল যে যাহা হেলে বি লিভ গ্রান্ট হবো তাহলে দেখান্তু বিকজ মিস্টার আচার্য's point is that admit ଆପଣ ବି କହୁଛନ୍ତି লিভ ଆଲାଉ କରନ୍ତୁ. Can it be?
ଆର୍ଜନ କଥା ମୁଁ ଦେଖିବି କଣ ଜଜମେଣ୍ଟ
This is that then it would not be a judicial process. Then revision would not be a judicial process. If so much of discretion is granted to a judge, if he likes, he will issue, he will admit, he will grant leave. Can it be? Can it be? This kind of uncertainty. Mr. Adhikari Chittaranjan Das for the petitioner, Mr. Standing Counsel for the State, the learned counsel for the petitioner. The petition has been filed, likhi diyontu. So and so pura detail likh debe. The learned counsel for the petitioner was heard at length, particularly regarding the finding of the learned trial court that exhibit 4 and 5, that is the purported memos issued by the bank regarding by the bank to the complainant account holder regarding insufficiency of fund were disproved. But the learned trial court returned a finding of guilt as far as the opposite party is concerned. The learned counsel seeks further accommodation to advance further arguments. When do you want?
December 2nd. Yes.
As prayed for, list on 12 11 12 କେବେ ଚାହୁଁଛନ୍ତି? 12 December 12 2023.
Item 12.
I am in PC, my lord.
Yes, please.
I am appearing in behalf of M. Das.
Mr. B.C. Mohanty,
Yes, my lord.
for the petitioner. Yes, what do you want, sir?
As per M. Das absent 2 weeks after, sir.
Who is the Dhaneshwara? Who is this person Dhaneshwara? He is the co-accused.
One of the main
Yes.
accused.
You want adjournment?
Due to his illness,
The learned counsel for
I
the
prayed for
petitioner
2
seeks
weeks.
accommodation to advance arguments. As prayed for, list on. केबे 2 weeks कहले ना 15/12/2023. The case diary and the
Once is for statement of the
learned
victim as
standing
well as the
counsel
medical.
submits that to grant further opportunity to the petitioner. The learned standing counsel submits that the case diary along with the statement of the victim recorded under section 164 of CRPC is available. Yes.
Item
15 December. Shumanti.
13 minutes.
You want further time or what?
That's 3 times.
କଣ ଦେହ ଖରାପ ହେଇ ପାଖରେ ବସିଛନ୍ତି ସିଆଡକୁ ଅନଉଛନ୍ତି ଆପଣଙ୍କର ଡାହାଣ ପଟେ ବସିଛନ୍ତି
କାଗଜ ଲେଖିକି ଆଣି ପଢୁଛି.
yes
Item 13.
Petitioner got acquitted from the charge by the learned session judge.
The last we are also directed to take the instruction. And we got the instruction from
Mr. Amulya Ratna Ponda for the petitioner, Mr. Standing Counsel for the state. The learned Counsel for the petitioner reiterates his submissions as noted in the order dated 15/11/2023 that the petitioner has been acquitted by the Learned Trial Court from the charges on 20/10/2023 in connection with special case so and so. देखिए लिख देवे 15/11 राची
260/22
260 of 2022 by the Learned Session Judge.
additional
No,
sessions judge Balasore.
I have recorded, but that's a mistake. By the Learned Additional Session Judge dash Special Judge Balasore. The Learned Standing Counsel submits that he has also received instructions, the said instructions from the IAC, concerned IAC.
Exchange.
The petition stands disposed of. Yes.
14.
May I please, your lords?
Yes, please.
This matter is instructions permitted to withdraw, my lord.
The report asila Devod kotu.
Flag image. Flag image.
ଟିକେ ଅପେକ୍ଷା କରନ୍ତୁ ମେମୋଟା ଦେଇ ଦିଅନ୍ତୁ ମେମୋଟା ସେପଟେ ଦେଇ ଦିଅନ୍ତୁ ମେମୋ ମୁଁ ନଉଛି ସିଏ ନଉନାହାନ୍ତି none.
Sorry.
They are kind enough to bring that and hand it over.
Sorry.
To 11/23. ଆପଣଙ୍କର ମେମୋଟା କଣ କହୁଛନ୍ତି କହିଲେ?
Withdraw କରିବା ମତେ
No, that report is not there.
ସେଥିପାଇଁ ନୁହେଁ ମତେ ଗୋଟେ ମାସ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଦେଇଥିଲେ ତାପରେ ସେ ଯୋଉ
ବୁଝିପାରୁଛି ଆଜ୍ଞା ଆପଣଙ୍କ ଡାଉଟ୍ ଷ୍ଟିଲ୍ ଅଛି ମୁଁ ବୁଝିପାରୁନି ବୋଲି ବୁଝିବା ଦରକାର ନାହିଁ
ମୁଁ ସେଟା ୱିଡ୍ର କରିବାକୁ ଚାହୁଁଥିଲି
ଆପଣ ଚାହୁଁଛନ୍ତି ୱିଡ୍ର କରିବା ପାଇଁ ମତେ 5 ଥର କହିଲେଣି ମେମୋ ବି ଲେଖିଛନ୍ତି ସେଟା ବି ମୁଁ ଲେଖିବି ତାପରେ I have to wait for that. I can't accept that memo. ଆଣନ୍ତୁ ମେମୋ ଆଣନ୍ତୁ ଏଥର ଆଣନ୍ତୁ By order dated 2/11/2023, the following order was passed by the coordinate bench of this court. Order ta quote kar debe. The Learned Sessions, in terms of the above order, the Learned Session Judge Devgad was to furnish a report. ଆପଣଙ୍କର ଲାଷ୍ଟ ନୋଟିଂ ଟା କେବେ ଅଛି? But 16 ନା 10 ଲେଖା ହେଇଛି ସେଟା ଆପଣ 16 କହୁଛନ୍ତି ରିପୋର୍ଟ with a letter number 1627 dated 10/11 ଦିଟା ଫ୍ଲାଗ ଏମ ହେଇଯାଇଛି ନା ଗୋଟେ ଭୁଲ ଲେଖା ହେଇଯାଇଛି 16 ନୁହଁ ସେଟା 10. However, after କଣ ଲେଖିଲେ furnish a report which is not available in the records. The registry shall ensure that report in terms of the order passed by the coordinate bench dated 10/11/2023 is obtained from the 2/11. But a reference କାଇଁ ମିଳୁନି? କଣ ବେଲ ରେ ଗଲେ ନା ଆକ୍ୟୁଟାଲ ହେଲା?
ଆକ୍ୟୁଟାଲ ହେଇଛି।
ଆକ୍ୟୁଟାଲ ହେଇଛି।
ସିଏ ଯେତେବେଳେ ଇଣ୍ଟ୍ରିମ୍ ବେଲ୍ ରେ ଗଲେ thereafter participated and
ଇଣ୍ଟ୍ରିମ୍ ବେଲ ରେ କେବେ ଗଲେ?
interim bill reference is not there, but the IAC has sent the memo forwarded by the court to the police station regarding acquittal of the petitioner. Madam. He has forwarded that.
ଏଠି କିଛି ବିଏଲ ଏପିଏଲ ପେଣ୍ଡିଂ ଥିଲା କି ନାହିଁ କିଛି ଲେଖିଲେନି ଆକ୍ଚୁଆଲି।
Madam.
କଣ ଲେଖିଲେ?
ସେଟା ବେଲ୍ ଟା ପେଣ୍ଡିଂ ଥିଲା।
ତା ପୂର୍ବ ସେଣ୍ଟେନ୍ସ ଟା ପଢନ୍ତୁ।
12-10-23 ରେ lordship kindly have a glance. 12-10-2023 order.
Which is not a category ଲେଖନ୍ତୁ which is what is a report stop कर दियंतु।
Prior to that
by email from the registry to the additional sessions come special judge Devgad dated 8/11/2023. Instructions were sought for in terms of the order past order dated 2/11, which is the email is on record. Email is placed on record. Apparently, in response to the said email, the letter number 1627 dated 10/11/2023 has been received, indicating that the accused Shiva Munda was acquitted by order of disposal dated 5/9/2023. By order of disposal, by order dated 5/9/2023. Para the registry shall place the said report for perusal of the learned judge, the learned coordinate bench that had passed the order dated 2/11/2023. Yes.
So interim bill
The learned counsel for the petitioner files a memo. Files memo dated 23/11/2023, stating that the petitioner doesn't want to press the bail application. The memo is taken on record to be placed along with the matter before the appropriate bench. Yes, Mr. Mahapatra, what you were saying?
My lord, as per our order, he had released on interim bail on 10th.
That I have marked.
My lord.
Then whether he has surrendered or not, because that interim bail order actually I went 17/8/2023.
My lord, probably he has not surrendered.
17/8/2023. Then it was directed to be listed on 21/9.
My lord.
It was not listed on 21/9.
No. Never listed.
But again, 12/10 it was listed.
12. Yes, ma'am.
Yes.
He's not bringing the actual facts happened there. My lord, the sequence, my lord, after releasing on interim bail,
with the condition that to marry the, that is the order sheet I.
Yes,
found,
yes,
right?
I
To
marked
marry
that.
the victim. After marrying, my lord, deposition must be given, given there, and
No,
based on that, I could
The
tell.
other difficulty is that matter was not listed on 21.9.
Yes, my lord. That has not been listed.
Then the response of the learned the additional session judge doesn't disclose whether any bail was pending or not.
Yes.
But I think it should go to that bench
Right.
that had passed the orders.
Right.
Yes. 15, Mr. Sahu.
Yes, Lord. Lordship kindly see the learning trial court reported Lordship at flag age.
Last order was 611.
Yes, Lord.
910, 1810, then 611. Has not yet appeared before that court. Pursuant to the order dated 6/11/2023 passed by this court, the learned additional district and session judge Paralakimundi with a letter number 4381 dated 18/11/23 has intimated through the registry the following. Haichi, further, the last paragraph achi, further on 1/9/2023 up to has not been made till date. In view of such communication from the learned additional district and session judge, the registry shall obtain a further up-to-date report for perusal of the court. List on आज कितनी तारीख है 23 list on 14. The learned counsel for the petitioner reiterates his prayer for withdrawal of the bail petition, which was earlier also refused in the order dated 18/10/2023. Sorry, withdraw kartile kebe also refused on 6/11/2023. ସେଟା ଆସୁ ତା ରିପୋର୍ଟ ଆସୁ ତାପରେ yes, next.
16.
May I please, Your
Sushant
Lordship?
Kumar Lenka for the petitioner. Yes.
Can you last the
SS
last order?
Mahapatra.
9/10/2023.
Mr. SS Mahapatra AC for the state. That
Yes, my lord. Instruction from the jail medical, my lord, was received.
What is the quantity here
Quantity matlab 115 kgs
in Puri?
only.
Petition is a driver.
In Puri.
Puri, Dellang, my lord. Puri. Also, while my lord transporting in Wagner car,
Sorry?
Transporting in Wagner car, my lord, he was found with the ganja, and from his person it was recovered 115 kgs ganja. And also the medical report, lordship kindly have a glance, all adequate medical my lord, facility has been provided to him, including the treating him in different hospitals, including in SC Medical College and hospital. There find no such emergent medical requirement for his entry and release, as I find from the medical report.
Mr. Lenka, I think he is not taking care of his health. Rather, thanks to you, after the order by the court, he has been intensively treated and all that. So, I would have report Adam, but his health condition is poor.
He complains of pain.
His health condition is poor.
I will bring the
Actually,
Well, actually, as per my instruction from his wife, so no one had the medical with treatment. As per my lord's direction,
Jetadin Tagar wife care no thile, I can tell you confidently that
my lord's order
he was not taken care of.
well, actually, my lord's order
ଆପଣ ଗୋଟେ ବି ଆପଣଙ୍କ ପାଖରେ ପ୍ରେସକ୍ରିପସନ ନାହିଁ
ପୁରୁଣା
କେୟାର ନଉଥିଲେ
ପୁରୁଣା ପ୍ରେସକ୍ରିପସନ
ଗୋଟେ ବି ନାହିଁ କିଛି ନାହିଁ ତାଙ୍କ ୱାଇଫ ଜାଣି ବି ନାହାନ୍ତି ତାର କଣ ଡିଜିଜ ହେଇଛି ଏଟା ଆମର ଟିପିକାଲ
interim bill. There will be
ଆପଣ ତା ରେକର୍ଡ ସେଟା ଆଣି ନାହିଁ ଦଶ କଥା ରିପୋର୍ଟ କିଛି ନାହିଁ
report.
ଆପଣ ସେଟା ସବୁ କପି କରିକି ନେଇ ଆସନ୍ତୁ ଦେଇ ଦିଅନ୍ତୁ ଠିକ ଅଛି ସେଟା ଆଣିଲେ ତାକୁ ରଖିଦେବା ଏଟା କୋର୍ଟ ୱିଲ୍ ଡାଇରେକ୍ଟ when court directs he will be treated differently ଆଉ ତାଙ୍କ ସ୍ତ୍ରୀ ଯଦି ତାଙ୍କର କେୟାର ନଉଥାନ୍ତେ ତାଙ୍କର ଏସବୁ ଜିନିଷ ହେଇନଥାନ୍ତା The pursuant to the earlier order dated 9/10/2023, reiterated on 3/31/10 and 13/11, the learned Additional Standing Council produces the report received from the Superintendent of District Jail Puri, dated 18/11/2023. Enclosing report of the medical officer, District Jail Hospital Puri, 18/11/2023. Regarding the health condition of the petitioner. It is indicated that apart from the being treated at the jail, the hospital at inside the premises of the jail, he has been the petitioner has been medically examined with different pathological tests, consulted the specialty department of pulmonary medicine at the Sri Jagannath Medical College and Hospital Puri. He is now being treated for diabetes, blood pressure, high cholesterol, acidity on daily basis as per the advice of the jail medical officer. The report of the medical officer indicates that he has been given देखिए लिखि देबे bronchodilator, anti-asthmatic, cardiology so jal achi, has been given different medicines due to the multiple health issues suffered by him. Regarding the statement made in the petition that the petitioner was suffering from tuberculosis, he has stated before the doctor that he was taking anti-tubercular drugs and completed the full course 2 years back. Presently, after consultation with the with the specialist in pulmonary medicine, he has been advised with various drugs. Investigation status कौन charge sheet दिया सर
Investigation CD was not called for
Charge sheet sir,
case diary has not been received. If your lordship is keeping to another date,
case diary नहीं आसुंतु
I will
My lord.
के दिन टाइम नउचंतु के दिन समय केते दिन लागिबो
only within a week, lordship. From Puri will be getting.
Pardon me, Lord.
ता भितरे से चिकित्सा हेबे ना आपण चिकित्सा भी करे दियंतु
Yes, ma'am. Lordship then
Charge sheet है कि trial start है मो पाखर अछि charge sheet copy.
दियन कॉपी ताकू देबे ना मु कोन फेर दे
for further treatment report if necessary, lordship.
जी सेटा देखिया कथा आपण ताकू धरि के बसिबे ताकू तो दे दै थांदे सीधा देखि दै थांदे so that
Charge sheet has been filed. And this is the only accused keeping investigation open. It has been filed.
there must be some mastermind.
Yes.
The persons who are driving car and in the bike they are carrying, they are never
There is
they are never the mastermind or the main accused.
a transporter come consumer.
अंकर जति मेडिसिन खर्च वर्तन हेलानी कोन करिवे
The medical report
निहाती हेल्प अपने हॉस्पिटल ले कार्ड फार्ड करी चिकित्सा हवा दरकार.
medical report shows, my lord, what I gone through, lordship must be going through. My lord, he is a transporter come consumer also.
सेतिमें टीबी हेतियो
Seithipai, my lord.
आपनकर those who are addicted to smoking or more ganja, there is
Yes.
likelihood of suffering pulmonary cox.
Yes.
से किनी पालेनी बोली भाबिले जे मु चलेबी पाखरे थुआइथिले मझरे मझरे ए आ से जे बर्तन तांगर जो लंग्स कंडीशन जा अछि because he is in jail.
Ambedkar jo case.
कौन लिखे various drugs. Referring to the fact that the petitioner was the only occupant of was driving the vehicle which contained in its boot in boot space. Mr. Naik educated that in the boot space the contraband and still the investigation is kept open and also the fact that the quantity is much more than the commercial quantity.
Yes, 115 kg.
115 kg
And he is the only accused implicated so far.
The opposes the prayer for bail. The learned ASC also refers to the provisions of section 137 37 of the NDPS Act
NDPS.
to oppose the prayer for bail. Having heard the learned counsel for the petitioner, the learned standing counsel, considering the somewhat precarious health condition of the petitioner, this court is inclined to grant bail to the petitioner as an exception. With a hope that he shall, after being released on bail, he shall be able to get himself treated for the medical conditions in a much better manner. The bail shall be granted subject to such stringent terms and conditions that would be imposed by the learned court in session of the matter.
My lord, interim bail or bail granted?
Bail. That would be imposed by the learned court in session of the matter in the facts and circumstances of the case. It shall be open for the learned court in session to hear the learned counsel for the petitioner and the learned counsel, the public prosecutor, before imposing such conditions. Apart from the conditions that would be imposed by the learned court in session of the matter, the following conditions shall also be there, that in case of violation of deviation from any of the terms and conditions that would be imposed, shall result in filing of petition for cancellation of bail by the investigating agency.
May I pray one thing, my lord?
Yes.
My lord, since there is every apprehension of his abscondence because he is the only accused in this case and a trial will be foisted, Lordship kindly have a further condition that any of the surety will be his relation, my lord.
First condition likhibe that there shall be two sureties. One of the sureties shall be his relation. Shall be relation of the petitioner.
Yes.
Actually, that I have left open.
Obliged. That is I know.
Rather, I was because he could have argued that because since I have left it for the prosecution and the petitioner to argue regarding the conditions.
Might not be in the knowledge of the PP or my lord.
Okay.
Usually, what happens when presenting the bail application before the law court below, without asking the PP, my lord, conditions are being imposed.
Okay.
In general condition.
General condition. There shall be a condition regarding the petitioner reporting to the police station.
Yes, my lord. Regularly, or in a fortnight or.
There shall be a condition in terms of the order that would be passed by the learned court in session of the matter. The petitioner shall cooperate. सेटा जो condition दीटा नहीं cooperate करिवे, interfere करिवे, सेटा लिखते हुए. सेटा लोग रखी दे होता. Petitioner shall cooperate. Yes.
Yes, ma'am. Obliged.
But I was inclined to think that also the learned court should take the note of his precarious health condition.
Well,
it actually he should have been there for at least more 15 days.
Yes.
से तांकर फर्दर इन्वेस्टिगेशन हे जाइथिले से आ करिवेनी से वर्तन बुलिले तापरे
नहीं आउ
से आ इन्वेस्टिगेशन किछ करिवेनी बुलिबे एबे
going downward.
हां से जो रेस्ट्रिक्शन रही गले that is how he has maybe there was a hope for his improvement.
Putting everything whatever given in the government side, it is sufficient.
Medicine
at least
he doesn't take medicine.
Yes.
Any event in yes, next
17
7 see 8 জন হয়ে যাচ্ছে called again to be called again. Next, so Manti 18.
Allegations are under section 420
କଣ ହେଲା ଆପଣ ସବୁ ଥର ସେ କହୁଛନ୍ତି ସେ
ତାର ଗୋଟେ affidavit ଦେଇଛି ହଜୁର କହିଥିଲେ ଆଉ ଗୋଟେ decision ରେ of this honorable court ସେଇ ଲୋକ similar person in another case he was in custody and this honorable court was pleased to release him bail. I have filed the order of the in the affidavit. In terms of the decision of the honorable Supreme Court in Satyendra.
Yes, sir, this is in nature of order. There is no binding precedents of these orders.
Yes, I am just drawing to your lordship's attention. I am not saying that he binding. And I have filed an affidavit.
I will draw your attention to what? Guess what I am going to tell you.
What is the amount I have?
Regarding decision. Amount ଆପଣଙ୍କ I am not imposing any condition.
No, ଆପଣ last order କହିଥିଲେ
Satyendra Kumar until para 90 to 95.
ଆଜ୍ଞା.
It starts with economic offences.
ଆଜ୍ଞା.
So ସେଥିରେ ଅଛି Satyendra Kumar until para 90 to 95.
Relying on the said decision.
ଯୋଉଟା ଆପଣ rely କରୁଛନ୍ତି para 90 to 95 have been noticed.
ନାଇଁ. And then I have
ଆପଣ ଯଦି ଟା ଦେଲେ କି
ଆଜ୍ଞା
ଏଟା କୋ ମୁଁ କଣ ଭୁଲ ବ୍ରିଫ ଦଉଛି କି I'm sorry 622 ଏଟା କେତେ 18
6686
ଦେଖନ୍ତୁ ଆପଣଙ୍କ ମୁଁ ବ୍ରିଫ ନ ଖୋଲିକି ବି କହିଦଉଛି ମୋର ମନେ ଅଛି
ଆଜ୍ଞା ଆପଣ 820
ସେଟା ମୁଁ ଆଉ ଗୋଟେ ବ୍ରିଫ ଖୋଲିଥିଲି ଏନିୱେ ହଁ କୁହନ୍ତୁ କଣ ହେଲା
ଏଥିରେ affidavit ଦେଇଛି
ସେଟା ଆପଣ ଯଦି ଦେଇନାହାନ୍ତି ସାର୍ ଟାଇମ ନେବେ ଯାହା କରିବେ
ଦେଇଛି on record ରେ ଅଛି ସାର୍
ଅଛି
ଆଜ୍ଞା affidavit ଦେଇଛି record ରେ ଅଛି ମୁଁ 5% of the alleged amount ଟା cash ଦେବି ବାକି ତାକୁ property ଦେବି ଆପଣ କହିଥିଲେ ସେତିକି ବୁଝିକି ଆସିବେ
ଆପଣ 5% ନେଇ ଯାଉନାହାନ୍ତି ସେଟା ଗୋଟେ ପ୍ରେୟାର କରୁନାହାନ୍ତି କୋର୍ଟ ଦେବେ I have been encouraged by the bar that I will be more charitable. 5% କେତେ ହଉଛି sir କେତେ
because financial implications are there. If he release
4 weeks
4 weeks.
uh, 7973
ଆଜ୍ଞା
ଦିଟା ଆପଣଙ୍କର ଅଛି ଆରଟା କୋଉଠି ଅଛି କି
27 item 27 ରେ ଦିଟା ମ୍ୟାଟର ଅଛି
15 27 15 ଆଉ 27 ମିଶେଇକି ଲେଖିବେ ଆଉ 15 27
ଆଉ ଗୋଟେ 29
15 27 29 separate IAs
21 27 and 29
yes separate IAs are there
ଆଜ୍ଞା
so ଲେଖିବାରେ କିଛି ଅସୁବିଧା ନାହିଁ
21 27 29 item 27 ରେ ଦିଟା
yes by IA 1544 of 2023 when the matter was taken up on 22/11/2023 the following order was passed in terms of the above order the learned standing counsel produces the instructions received from the IAC Udola police station in the district of Mayurbhanj received through WhatsApp which indicates that the statement made in the IA regarding the unfortunate demise of the mother of the petitioner is correct. The date is also the date of the date being 20/11/2023 as per the information received as per the records of the sub-divisional hospital Udola Mayurbhanj SDH para had learned counsel for the petitioner who seeks for interim bail. The learned standing counsel referring submits that in case the interim bail is granted, it shall be subject to such terms and conditions that will be imposed by the learned court in season of the matter. Having heard learned counsel for the petitioner, the learned standing counsel, the court directs the petitioner to be released on interim bail for a period of 4 weeks from the date of his release from the jail custody, subject to such terms and conditions that would be imposed by the learned court in season of the matter. After completion of the period of the interim bail, the petitioner shall surrender before the learned court the surrender certificate / order indicating such surrender. Order indicating surrender shall be obtained and filed before this court to be taken on record. The instruction furnished by the learned, a copy of
Yes, sir.
the learned by the learned standing counsel is also kept on record. List 4 weeks ago, kebe as paribo 25 नहीं 25 तो छुट्टी अच्छी 18 वीक डिसेंबर 18 जो वीक रे केबे 22
21 or 22 years.
22 रे आसो 21 रे आस्ताव लास्ट वर्किंग डे
Aista ଟିକେ
लास्ट वर्किंग डे 21 12 20 23 then you are saying after 15 it is 27 27 IA 1546 जहाँ लिखा है से आता हो कौन
again मतलब dear lordship में
इंस्ट्रक्शन दा सबुतरे लगे देबे गोटे इंस्ट्रक्शन लगे देबे
instruction that is from one police station मतलब
enough
yes
because his place of residence
yes
इंस्ट्रक्शन दा कॉपी करी सबुतरे रख देबे 27 परे 29 IA 1550 okay yes same order just replicate करिया कथा
छुट्टी पर को kind of 4 weeks from the date of release.
That is mo seit pain to 21 rakhili. There is a possibility that it may not be taken up. So apna 21 rakhi thante dekhiba.
After vacation hele in the meantime.
Nahi apna pare extend kariya padibo. Mu seta ebe to
after vacation rakhile mu nei asi surrender certificate ta after vacation mu surrender certificate de debi ethi.
Nahi darantu apankara 4 weeks complete he jibo se
then aji give it for 5 weeks that will be 5 weeks
kar diyo
reopening re kholle
ha 5 weeks
5 weeks this term fourth of
January
3rd of January yes
22
may I please on behalf of Mr. Lenka Miller.
Yes, please.
It is very difficult to getting instruction from the petitioner.
Your name, sir?
KC Behra.
What power nahi?
No, my lord.
So KC Behra on behalf of SK Lenka for the petitioner. But whenever you are appearing regularly, file your that memo. Because the learned counsel for the petitioner submits that there is some difficulty in getting instructions from the petitioner through his relatives who are looking after the case, and the matter may be urgent. How much time, sir?
In December.
Accused
person granted interim bail by your lordship, and lordship direct to order, scan the order copy and tag with this bail application, the last order. The MD
interim bail. Interim bail ko uthare
810023 bail fail number.
नहीं आपण जदि इंटरिम बिल इथरे पेंडिंग अछि तार रेलेवेंस थाई पारे जदि नाही आपण फाइल करिवे कॉपी देबे इंस्ट्रक्शन आनिबे ताहाले किछि तार रेलेवेंस सो आपण जस्ट सिंपली अर्जन कर दियंतु डिवाइस व्हाटएवर यू वांट स्ट्रेटजी डिसेंबर केबे कह लखले कोन डेट कोंतु
डिसेंबर सेकंड वीक
तीनटा वीक अछि आपणकर नेक्स्ट वीक इज जदियो नवंबर डिसेंबर आरंभ होई
डिसेंबर सेकंड वीक
14 14 12 20 23 आपण जदि फाइल करछोंती ताले सर्व कॉपी इन एडवांस ता परे एटा लिस्ट पूर्वरु आपण 7 दिन आगुरु देबे आपणकर होची कोन आपण जो दिन आसुची से दिन फाइल करछन कोन इंस्ट्रक्शन आनिया पई सो ऑब्वियसली द मैटर विल गेट अर्जेंट
आई विल फाइल
No, I am not saying that you will file. I am saying that if you are thinking that in that line, then you have to do it.
Yes. File earlier, man.
Mr. Appearance लिखिए Mr. Naik. ना AK Naik standing counsel, ना additional standing counsel. Additional standing counsel along with Mr. Bhuya. Mr. B. Bhuya, special counsel into bracket OPID. Then second matter.
In second matter, he is on interim bail.
Okay.
The Lordship directed to list this matter on 8th of.
But since it is connected, it has been
yes,
tagged.
Yes.
देखो ताले कोन एटा 3 इंट्री मर्डर 4 वीक्स हेतला डिस्टन 15 बार एटा हिच सेटा भी 15 बार कर दियो थैंक यू
Obliged.
ताले पूर्वटा 15 बार एटा 15 बार एकाठी आस परिबो यस
23.
यस मैडम
Your Lordship, last occasion, Your Lordship directed to file criminal antecedent affidavit file, but his family members, nobody come today till Your Lordship. As per instruction, no criminal antecedent.
affidavit shall be filed on behalf of the petitioner indicating past allegations of criminal activity comma if any देखो लिखी 6 accommodation yes केबे चाहउछंती आज prayed for December
Your Lordship.
as prayed for list on 11 December
No, Lordship, I am some
Further time?
difficulties, Your Lordship.
January
Your Lordship, reopening.
January चाहउछंती
Your Lordship.
4th January
Always.
4th January 2024 as per your report case diary is there antecedents are there
Case diary available.
antecedents
No, available.
the is there
No.
no antecedents
No.
so then why you are not saying that आपण verify भी करना थी ता माने पचार भी ना what is the offense alleged offense
मतलब 304
304 part 2, Your Lordship.
rash and negligence driving caused death of one person. Malad.
since prosecution report submitted
Charge sheet filed. Man.
पण you are not आपण merit track argue करिवे ना court will not assist you केते दिन रहलेनी custody रे
He has
25/4/2023.
एप्रिल मासरू
Again.
लेखन काटिले though by order dated 31 no by order dated 31/8/2023 the coordinate bench of this court had directed to obtain the case diary and further directed the petitioner to file affidavit indicating criminal antecedents comma if any on 21/9/2023 the state council was again directed to obtain the up-to-date case diary. On 7/11/2023 the Lord Counsel for the petitioner sought for adjournment to comply with the earlier order dated 31/8/2023. Para. When the matter is taken up today, it is submitted by the Lord Counsel for the petitioner that despite her best efforts, she has not been able to contact with any of the relatives of the petitioner who are looking after the matter. However, it is submitted that as per the matter stop para. The Lord Additional Standing Counsel referring to the case diary submits that as per the police report,
yes,
there is no past allegations against the petitioner as far as criminal activity is concerned.
Yes.
Para. It is submitted by the Lord Counsel for the petitioner that the petitioner is in custody since Date टा कहि परिबे date
25/4/2023.
2023. In the meanwhile, the final prosecution report has been submitted on Mr. Mahapatra.
Hello. Charge sheet file.
Yes.
Sorry. That is 6/6/2023.
6/6/2023.
Under section.
Under section
279.
279.
337.
397.
No, 279. 279 337.
279 337.
304 part 2.
304 part 2. For part 2 रे बधे minimum offense fine.
Well,
part 2 रे minimum offense केते fine बधे
10 years. Part
Minimum
1 life, it can be extended to life, and part 2 is 10 years.
10 years.
10 years, up to 10 years.
लिखले the lauded submission कहाँ लिखते ले petitioner कर the lauded additional standing counsel refer to the materials contained in the case diary opposes the prayer for bail. However, it is not disputed at the bar that in the meanwhile the final prosecution report has been submitted. Para. It is submitted by the learned counsel for the petitioner that the petitioner being a local person, he shall subject himself to the jurisdiction of the learned court in session of the matter and shall also abide by the terms and conditions that would be imposed for grant of bail. Para. Having heard learned counsel for the petitioner and the learned additional standing counsel for the state, this court is inclined to grant bail to the petitioner subject to such terms and conditions that would be imposed by the learned court in session of the matter. The petition stands disposed of accordingly. Yes.
24.
24 tango
24 May lordship my lord I am in VC my lord
ताको भी नहीं आसंतु पिप ताको भी पिन कर दियंतु yes what do you say sir
my lord 24 my lord can you be taken my lord 2 weeks after my lord can you be taken 2 weeks after my lord
Mr. Sabat, you are appearing for?
Yes.
For the informant or?
Informant. Informant.
You are the special public prosecutor or you are the informant, sir?
Informant.
But if you are a prosecutor, don't appear for informant. Please, that the neutrality of prosecution has to be maintained. In our system, our jurisprudence. No, you are sure you are not a public prosecutor. I understand that you are assisting. You can assist the standing counsel here. But are you a public prosecutor?
No.
Again, sub koti hoche actually.
No, sir.
Kon kouchanti?
Neither.
Nahi.
No.
Mr. S.K. Tripathi for the petitioner.
My lord.
S.S. Mahapatra AC for the state. Mr. S. Sabat for the informant. The lauded counsel for the informant being present at the virtual court, Gajapati. Virtual court, Odisha High Court at Gajapati addresses arguments. What is your instruction, Mr. Sabat? Regarding the prayer for bail, what is your instruction?
There is every chance of tampering with the prosecution evidence with the accused.
ଆପଣ ଟିକେ ଦୂରକୁ ରହି କୁହନ୍ତୁ ମାଇକ୍ରୋଫୋନ ଟା ବହୁତ ପାଖ ହେଇଯାଉଛି କାରଣ ଆପଣ ତ ପ୍ରପର ଭିସି ରୁମ ରେ ଅଛନ୍ତି ଇକୋ ହବନି
There is every chance of tampering with the prosecution evidence if the accused is released on bail, also every charge to
Yes, you are
threaten-
opposing. You are opposing. Mr. The learned counsel for the petitioner seeks accommodation to advance arguments. The learned additional standing, the learned counsel appearing for the informant opposes the prayer for bail to grant further opportunity to the petitioner list on 2 weeks after Kuchundi. 19th, 19th is 19th, Mr. Tripathi, 19th December.
My lord. My lord, my lord.
19th, 12/20/23. The learned
Case diary-
AC submits that case diary is available.
Just now received.
Case diary has been received.
Received today.
Yes.
25.
My lord, as per the instruction of this honorable court, I have filed the charge sheet and deposition copy of the case on dated 14/11/2023. My lord, most of the prosecution
Just wait, sir. Filing is not enough. ଆପଣ up to PW1 ରୁ କୋଉ ଯାଏ ଫାଇଲ କରିଛନ୍ତି?
the PW1 to PW5.
ସେଥିରେ important witness କିଏ କିଏ ଅଛନ୍ତି?
5% of file.
Informant.
He is the victim of 6 years old, my lord.
3.
354, 354A and 8 POXO is there. My lord,
For judgment item 1.
Though the judgment runs to several pages because the contentions were large in number and obviously the citations, but I have referred to Satyendra Kumar Until and Ratnambar Kausik, the principals. So, I'm reading out the last but one paragraph. It is true that the allegations made against the petitioner is that he received the benefit of the amount that was granted to different entities to the tune of rupees 7,79,52,000, and it is contended by the prosecution complainant that there is likelihood of the discovery of more such transaction. But it is also not disputed that the final prosecution report has been filed in the case. The petitioner was arrested on 11/7/2023, incarcerated for more than 4 months, and the punishment provided is imprisonment, which may extend to 5 years, and fine and completion of trial in any event would take some time. Since the alleged offense constitutes the act of creating amount of the ITC through the departmental online system to the account of the certain entities, which have been alleged to be non-existent, and the money has been subsequently received by the petitioner, the evidence tendered by the opposite party complainant would essentially be documentary and electronic. The ocular evidence will be through official witnesses of the department, due to which there can be no apprehension of tampering, intimidating, or influencing. Therefore, keeping all the above aspects in the perspective in the facts and circumstances of the present case, by applying the principles enunciated by the Honorable Supreme Court in Satyendra Supra and Ratnambar Supra, this court is inclined to grant the petitioner grant the prayer for bail made by the petitioner, subject to such stringent terms and conditions that would be imposed by the learned court in season of the matter, for which the court shall hear the learned counsel for the complainant as well as the learned counsel for the petitioner. And further conditions as would be deemed appropriate can be imposed along with the following conditions. So this court has imposed conditions. Shall I read that out?
As your lordship pleases.
Two sureties for an amount of the satisfaction of the learned court in session of the matter. Out of the two sureties, one shall be a family member of the petitioner and the other shall be a local person. The court in session of the matter shall ensure and verify the credential of the sureties. The court shall direct and record its satisfaction. The petitioner shall not in any manner make any inducement, threat, or promise to the prosecution witnesses so as to dissuade them from disclosing truth before the court, and shall not tamper with the evidence. The petitioner shall not indulge himself in similar activity. The petitioner shall surrender his passport, if any, before the learned court in session of the matter, and will not leave India without prior permission of the court. And in the event the petitioner has not been issued with any passport, he would submit an affidavit stating the said fact. The petitioner shall appear before the concerned authority as would be so required. For the purpose, he shall appear before the police having jurisdiction for his area, jurisdiction of his area of residence, if directed by the learned court in session of the matter, in the manner to be decided by the learned court. The petitioner shall fully cooperate with the ongoing further investigation and make himself available anywhere as and when required for such purpose. The petitioner shall be available to be contacted over mobile phone, and such phone should remain active and normally not be changed. And in case of any change of the mobile number of the petitioner for any bona fide reason, the same shall be communicated to the investigating agency. The petitioner shall cooperate with the trial and shall not seek unnecessary adjournments on frivolous grounds to protract the trial. The petitioner shall not indulge in any criminal activity or commission of any crime after being released on bail. In case of his involvement of any other criminal activities or breach of any condition imposed for grant of bail, the investigating agency shall file petition for cancellation of bail. The bail appeal is disposed of. Date is to be put at the last page.
Obliged, my lords, may I just make a humble prayer? My lords?
Yes, please.
So from tomorrow onwards, the lower courts will be on holidays for the last 4 days.
Great.
So may I just pray if your lordship would be kind enough to grant us a certified copy in course of the day?
ବର୍ତ୍ତମାନ ଆପଣ ପଠେଇ ଦିଅନ୍ତୁ.
I-
It will be uploaded also.
Manoj.
ଆପଣ ଏବେ
They may
ପଠେଇ
not be acting on an uploaded copy. They may be asking.
Yes,
for-
yes, yes.
So
You send it for certified copy formality ଯାହା ଅଛି ପୁରା
from
କରିଦିଅନ୍ତୁ.
Friday onwards, it will be 4 days holidays for the lower courts.
नहीं. Trial court ସେଟା they may not act on the certified copy.
They may not act on a downloaded copy.
Downloaded copy. ଆପଣ ଏବେ certified copy ପଠେଇ ଦିଅନ୍ତୁ. You have applied for you apply for
No,
certified
no,
copy.
we have already applied. Because I not have disturbed your lordships because from Friday onwards, it will be 4 days holidays for the
Yes.
courts below. Greatly obliged. my lords.
ଆପଣ ତା ପୂର୍ବରୁ ଯାହା ଜେରକ୍ସ କରିବା କଥା yes. Yes. Just as a matter of curiosity, both Mr. Mahapadra and Mr. Kara, apart from this person, anyone in the department has been investigated.
So far, my lords, I don't have any instruction regarding departmental officer being involved.
I mean, I also I don't suppose also that, but as far as the investigation is concerned,
my lords,
because the entire investigation you have presented, the substantial part has happened in the department itself. Because he is only the, if I have understood, subject to correction, of course, since it's a matter of trial, in fact, I have observed. Because that part I, last part, sorry, I think I have left the last page. That's clarificatory. It is clarified that any observations made in this judgment shall not be constituted to be opinion of this court regarding the merits of the contentions that would be raised in the pending trial before the learned court in session by either of the parties to the present petition. And the other part that I have also clarified, since the matter is before the learned trial court for consideration, any observation on merits herein is likely to prejudice the cases of the petitioner as well as that of the prosecution therein. For the limited purpose of answering the prayer for grant of bail by this court during pendency of trial, the above contentions have been taken note of. So this is the usual, I mean,
my lords.
Greatly obliged.
Yes. Certified copy ଟା facilitated କରିଦବ ସେ mention କରିଛନ୍ତି ଯେ କାଲିଠୁ ଛୁଟି ରହୁଛି ଯୋଉ ମୋର ବଡ ଓଷା and still that because there is a direction that you will be heard in before the court regarding the further conditions. It may appear that already there are so many conditions, but still that conditions you have to anything you want to further conditions they can impose. Yes,
that item 2 was there, my lord. She was supposed to file a memo. My lord has directed her to file when he played away.
कौन करे बुझु नांती आ कौन करे
मेमो देले
देले
এটা তো একদম না
सलोनी मानते ना कौन टाइम
two time. No, that was not shown to my lords. That was. Yes, she was told to submit the memo. It has to be put before my lord.
हाँ, I said कि आपण को काली adjournment देली आपण देले नहीं काली तो dispose हो गला 17 तारीख I'm sorry 17 तारीख तापर मते आनी फाइल प्रेजेंट करा हला मेमो नहीं आपण ऑर्डर कर देले मु फेर तक अथरे टू बी मेंशन आनिली सेटा त कहउतली मु आपण तथापि दउ नांती मेमो एटा अछि त धेरे मेमो अछि they have received the memo. Actually once they submit, actually I return the file for typing of the order. But after some time, maybe 2-3 days, then when the file is returned, they say that the memo has not been received.
On good faith, it is being done.
No, I mean, they don't understand also the difficulty. There is a possibility that without the memo, the file will be returned, the order will be signed.
Yes.
Only thing I am telling that if you do not submit, I am not passing the order.
That item 7.
Yes. We have sought for instruction from that mentioned matter to be mentioned. Since they are not giving the details, I have sought for the instruction from the Lord court in season of the, I mean, trial court.
Item 7.
3.
My lord.
Item 7.
They are challenging the order of show cause passed in my lord 110 proceeding.
None appears for the petitioner, though the matter is called twice over. Once at the beginning when it reached, and again after resumption of the proceedings, court proceedings after recess. Appearance non-liquid, Mr. Standing Counsel for the State. It is submitted by the Learned Standing Counsel that the petition was filed in the year 2014, challenging the order, challenging the show cause notice. Show cause notice under challenging the notice to show cause. Challenging the notice to show cause issued under section 110 of CRPC. That is dated 29/9/2014. To execute two TW, two good behavior bonds for rupees 1 lakh with TWO2 securities of two senior class into bracket Roman 1. SR dot class into bracket Roman 1. Annex 1 upon dekhi likhi paribe. Class 1 officers each who are in government service for a period of 3 years. The Learned Counsel for the Learned Standing Counsel referring to the said copy touch.
No,
you have okay. Referring to the said order passed by the Subdivisional Magistrate Puri, that the period of 3 years is long since over on around 29/9/2017. Stops opera. It is therefore submitted. Nothing survives for adjudication at present before this court. The petition stands disposed of.
17.
You don't have a brief cover even.
Well,
no, always have a cover, because I used to have some extra covers always, or the last page of your docket that you are using. I used to note that order because it is very difficult to track and remember. It's very difficult. That like you saw that the other day, yes. He showed me this dictation note that order has been dictated. I don't know. In so many cases, the order is dictated. In a disposed of matter, it is also dictated. There shall be engagement of legal aid counsel. So and so the notice issued to
that is.
And if there would have been a direction to you, maybe you would have pointed out that a disposed of matter. Next.
17.
None appears for the petitioner, though the matter is called twice over. Likhi debe pura se paragraph ta. To grant further opportunity, list on
5 bar.
5 bar ki se ta par week re diyo to 5 bar man to apna first week de duchan.
12 bar.
11 bar ki ha 12 bar. Case diary asla?
Yes, that case diary is there.
The Learned Standing Counsel submits that case diary has been received. Criminal incidents.
This file belongs to.
Okay, leave it there.
Yes.
Case has been issued, let it be. Sida asunante kon kare, it can't be taken up. Okay. Next, please.
Item 26.
Mr. Kuldeep Mahanti for the petitioner, Mr. Standing Counsel for the state. I'm sorry, Mr. Devasis Naik, AGA for the state.
May I please, Your Lordship?
Say,
Your Lordship, kindly.
affidavit copy serve hela par instruction asichi. That is in sync. That it matches with your instructions. The allegation kon achi?
My Lord, allegation 461
Highest offense kete? Kon?
7 year, my Lord.
7 year.
Yes, my Lord. Tribal magistrate, my Lord.
Kete varsh hala apno career build up karchandi se?
Career, my Lord, as for the
18 start karchandi.
2018. 17, my Lord, 2017.
2017. Age kete?
Age, my Lord, 26 years.
Mr. Kuldeep Mahanti, appearance likely, the learned counsel for the petitioner submits that the petitioner is in custody since
27th of June 2023.
27/6/2023. And the final prosecution report has been filed on?
Lord, no instruction.
So, like, jana paduchi kichi?
Until 29, my lords, it was not filed.
So, Mahanti,
30,
you should have been, after the last order was passed, you should have been updated.
No, it has been filed. It has been filed. I'll just give the dates.
Yes. The final prosecution report has been
22/8/23.
22/8/2023. It is submitted that though the petitioner has passed allegations of criminal activity against him, he should be given a chance to come back to the mainstream of social life.
22. My lords,
being released on bail.
It is not clear.
Not clear.
Preliminary charge sheet keeping the investigation open.
PPR. Preliminary prosecution report has been filed, keeping the investigation open under 173(8). 173(8). 133 into bracket 8 CRPC. Sentence na complete that he should be given a chance. Yes. The learned counsel, the learned AGA referring to the materials content by the content in the case diary produced by the investigating agency and the past allegations of criminal activity against the petitioner opposes the prayer for bail. However, this not disputed at the bar that in the matter, the preliminary PPR has been already submitted. Having had learned counsel for the petitioner and the learned AGA for the state, this court considering the fact that the petitioner is aged about 28 years.
26 years.
26 years. Hoping that he should mend his wage by coming to the being given a chance to lead a normal social life. Is inclined to grant bail subject to such stringent terms and conditions that would be imposed by the learned court in session of the matter, which shall also include the following conditions. One, that there shall be two sureties for the petitioner, out of whom one shall be his relation. any deviation from violation of any of the terms conditions shall result in filing of petition for cancellation of bail by the investigating agency oblique informant oblique victim, disposed of accordingly.
Item 28,
28, my lord, I pray for 2 weeks after, my
Mr.
lord.
Tukuna Kumar Misra for the petitioner, Mr. Naik, A.K. Naik, Additional Standing Counsel, along with Vivekananda Bhuya, Special Counsel for OPID. The learned counsel for the petitioner seeks further accommodation to advance arguments. January na December के बेचा हूँ
December last week, my lord. Yeah,
As
negotiation
prayed
is
for-
going on.
As prayed for list on or जो 28 week, I'm sorry, ମୁଁ November देखुଛି. List on 20 on 20 12 20 23.
Obligement.
सब आइटम कौन मिस्टर मिश्रा
Yes, my lord. Same.
आपको मैटर सब आइटम नहीं की
So,
हाँ ये
yes,
सेम ऑर्डर
same order.
सेम ऑर्डर सेम अपीयरेंस सब 29 ଟା ଯାଇଛି ଆପଣ ସେଥିରେ taken up together हाँ 30 non appears for the petitioner though the matter is called twice over ପୁରାଟା ଲେଖିଦେବେ ଏବେ ଆସିଲା report ଆସିଲା in terms of the order dated 6/11/2023 the letter number 637 dated 3/11/2023 has been received from the learned ASJ com special court under POXO Balasore that the special case number 168 of 2023 arising out of देखिए लिख देवे Singla PS case number so and so has been disposed of on contest by the court by the said court on 12/10/2023 acquitting the petitioner acquitting the opposite party into bracket who is the petitioner herein bracket closed from the charges and he has been released from the jail custody. The above information is in sync with the submission of the learned counsel for the petitioner recorded on 6/11/2023. The petition stands disposed of. Mr. Bhanjadev, Mr. Sanjeev Kumar Bhanjadev for the petitioner, Mr. Devasis Naik AGA for the state. आप पूर्व पटेटा appearance लिख ले देखिए करो. Yes. Yes, Mr. Bhanjadev.
Yes, may I please yours. Here, my lord, the petitioner is languishing in the jail custody 29/4/2023, near about 7 months, my lord. Here, my lord, last occasion, your lordship has also granted bail in one case to the petitioner and observed that the petitioner has 3 antecedents, including the present case, my lord, and granted bail with stringent terms and conditions, my lord. Here, in this case, my lord, the allegation is that
I mean the antecedent अच्छी कहोचते.
Your lordship
That is your submission.
Your lordship has
If I have followed you correctly,
yes, ma'am.
This case is one of the cases that was considered in that to be an antecedent.
Your lordship 2006 mentioned.
से order टा एठी लगेइछन्ति कि order
ଦେଇଛି
6/10/23
से जो comprehensive affidavit रे ଦେଇଛି.
नहीं हमर जो बर्तन सिस्टम डेवलप हेछि ना रजिस्ट्री ताको काढी की बाहर करछि. After प्रधानी जानी this thing is happening.
এটা BLA PLA 6572 by 2023.
Right. 6572 that is at page 12.
Yes, ma'am. Here in this case, my lord, the allegation is that
case diary अब status ये आपनकर
What I have received is the criminal antecedents.
अच्छा.
But I have not received instruction on the status of the health of the wife of the petitioner.
Wife no, that is a health condition of injured, my lord. Injured.
ଆପଣ IA ଟା
IA not press ସେଟା ମୁଁ interim bail ଟା not press
करिवेन तापर सबुटु स्ट्रेंज पार्ट हला जे आपनकर से रिपोर्ट तापर देबे जे से वाइफ बिल्कुल जाई नांती हॉस्पिटल in this during my also assignment I have faced that situation.
Well, the allegation is that two person came called to the
health condition रे आपनकर किछि अछि
The report, the health condition report I have
gunshot
received.
injury on the left upper black scapular region, scapular gun marile abdomen region
In fact,
penetrating
the victim
upper abdomen रे जाई कि तापर
victim has been examined. I have given the deposition copy also. PW6
incident टा केबे
2016
2016 रे तो
Yes.
भाग्य भलो बंची गेले केबे केबे एटा PW6
yes ma'am. PW6 page 16
आपनकर लाइसेंस गन तो किछि नथियो
से कुछ ये लोक ही नु ये सब
नहीं अच्छी की पचारचंदी because that order cannot be passed. We have a difficult. It is not like other country where their gun licenses are issued.
But I was here he has been examined. He has stated PW6 ma'am.
माने तांका ना होची
बिपिन
कृपा सिंधु
my lord. And he has I am not
आपण जेतोळे बेल सिक करचंदी आपण कृपा सिंधुଙ୍କର स्टेटमेंट आणुचंदी सेटा गोटे वेरी इंटरेस्टिंग कोइन्सिडेंस
and he has also stated I was examined by the police. It is not a fact that I have stated before the police.
Just I am going through that.
Yes, ma'am.
He has not said that the accused fired at him. That is your contention.
Yes, ma'am. And also not identified. Although he has stated in the affair, in the statement, that this.
No, he says the said culprit fired towards me. ଆପଣ ଦେଇଛନ୍ତି deposition copy, Mr. Naik, you are having.
He is refused to identify.
Refused, not identified also. Though allegation.
Oh, acha. He has been declared hostile.
Yes, ma'am. Declared as hostile. And 7 months in custody and local man. Your 1 month has also been passed. By
Mr. Bhanjadeo, the learned counsel for the petitioner submits that the petitioner is in custody since
from
29/4/2023.
29/4/2023. In the meantime, the trial has progressed substantially. The injured victim / witness has been examined as PW6. The statement of the said PW6 have been filed before this court and copy has been served on the learned AGA. The learned counsel for the petitioners submits that in view of the substantial progress of the trial and considering the period of incarceration, the petitioner should be shown indulgence as far as prayer for bail is concerned. Subpara. The learned counsel for the petitioner refers to the order dated 6/10/2023. Passed in BL APL number 6572 of 2023, filed by the present petitioner, where he was granted bail by this court. Para. The learned AGA, referring to the materials contained in the case diary and the depositions of the witnesses, opposes the prayer for bail and also refers to the past allegations of criminal activity against the petitioner. Petitioner boys kete?
Petitioner boys
51 years.
52
या रिफॉर्म कोन हेबे ये तो भलरे अछंती एठी.
What he has done, my lord, he started in 2013.
52.
Case number 4 of 2013.
52.
Then my lords
said
PS case number 156 of 2016. Then PS case number 296 of 2020.
So there is no difficulty in imposing different conditions in this matter because he is in custody.
Yes.
In custody.
So the learned also refers to the AG refers to the past allegations of criminal activity against the petitioner while opposing prayer for bail, and also submits that in case the court is inclined to grant bail, suitable terms and conditions should be imposed. Para, having heard learned counsel for the petitioner and the learned AG for the state, considering the material on record, this court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that would be imposed by the learned court in season of the matter. Apart from the following conditions, there shall be 2 sureties, one of whom shall be a relation of the petitioner. Then he shall not interfere with condition गुड़ाक नहीं की डेविएशन टा लास्ट ता पूर्वरा जो कंडीशन गुड़ाक आज जो तरह जजमेंट डिलीवरी जी सेटा इंपोज कर दे देवी अथरे yes disposed of accordingly.
Obliged.
32.
I'm yet to receive the CD also in this case.
You are Mr. Naik, SK Naik, Suchit Naik.
Yes, ma'am.
Mr. Suchit Kumar Naik for the petitioner, Mr. Devasis Naik, AGA for the state, the learned counsel for the petitioner seeks accommodation. Criminal proclivity पे मौका है थिले क्या पढ़ूं को?
No.
CD, my lord, was called for. I'm yet to receive it, my lord.
The learned counsel for the petitioner seeks accommodation to advance arguments as spread for list on
last week of December.
Last week of December. On 18th 18/12/2023. The CD has not been received. The learned AG shall obtain up-to-date case diary, instruction, stage of trial. All oblique. Stop. Yes, next.
33.
I'm not the petitioner, sir. This case, the petitioner, 2 petitioners have been in the jail custody since 7/7/2023. And the petition number
Mr.
1.
Ashok Kumar, you are Mr. Das, Mr. Ashok Kumar Das for the petitioner, Mr. Devasis Naik, AGA for the state, Mr. Trilochan Paningrai for informant. The learned counsel for the petitioner and the informant being present at the virtual court, Odisha High Court at Puri, address arguments. Yes. Yes, Mr. Das.
Sir, the petitioner number 1, sir, is in a family way. And since last 5 months.
Petitioner number 1, she is in the family way, I think.
Sir.
Pratima alias Rina Mani. That health condition I wanted. Yes.
The report was called for and the jailer has submitted the report.
So that's only concern is that today, coincidentally, that is also from Puri.
Sir.
The persons are not taking care of their health, they are not taking medicine. Once they become state guests, then adequate care is taken.
Yes, sir. That person, there is no allegation.
No, I was just asked, I was telling you the dilemma. That I'm informed.
It is a counter case and the counter case is there. गोटे सजना डाल
302 एते 302 अछि ना 302 अब काउंटर केस की गले जे चली गले
यस मैम
302 रे काउंटर केस कोन रिलेवेंस अछि যদি ଦିଟା 302 ହବ ତାହେଲେ ଆପଣଙ୍କର କାଉଣ୍ଟର କେସ୍ ର ରହିବ ସଜନା ଡାଳ ପାଇଁ ମାରପିଟ ହେଇଥିବ that could be trivial issue
ମେମ୍ବର ମାନେ ସବୁ ଆରେଷ୍ଟ ହେଇକି ଭିତରେ ଅଛି ଏ ଦିଟା ଲେଡି ତା ଭିତରେ ପଶିଯାଇଛି ତାଙ୍କର ଆଲିଗେସନ ହେଲା ଏ ଇଟା
obviously Mr. Das after your submissions in fact the
ସାତୁ ସାର୍ ରହିଲେ
the
Hello.
yes Mr. Panigrahi
Yes, ma'am.
overtact କଣ ଇଏ ଗୋଟେ କଣ କାଢିକି ଦେଇଥିଲେ ନା କଣ ପରା ମାରିବା ପାଇଁ
Yes, so far the statement of please make a glance. So far the charge sheet is concerned. Statement of the Nabagana Behera.
ନାଇଁ 164 ନା 161
161.
ସେଟା ଆଜ୍ଞା କୁହନ୍ତୁନି ମୁଁ ସେଟାକୁ ଲେଖିବି ଏନେ ମୋ ଜଜମେଣ୍ଟ ରେ ଅର୍ଡର ରେ ଲେଖିବି ଯେ 161 statement ରେ ଏହା କହିଲେ ବୋଲି ସେଟା କାଇଁ ଆପଣଙ୍କୁ ନାହିଁ ଆଜ୍ଞା Mr. Panigrahi
So far the statement of the corroboration is sufficient that they have also major roles.
anticipatory bail stage रे 161 प्लेस करा जाए काना इन्वेस्टिगेशन थाए आफ्टर चार्ज शीट इज फाइल्ड कोन किछि अछि आ फर्दर मैट ओवरटैक कोन स्टेट कोन कार 161 स्टेटमेंट पढिवा दरकार आपण कहि परिबे
So my response submission, the present petitioners are also ill-tempered person. They have conceived plan, my lord, to allege crime, my lord. Because they are the kingpin of the crime. They have also
how the moringa tree came into picture?
Because my lord, so far the order
pre-conceived plan re moringa tree kin majra asi gala. So should I be konthu actually that doesn't got any ସଜନା ଗଛରେ କଣ ପ୍ଲାନ୍ କଲେ ମୋ ଆପଣ ଯଦି କହୁଛନ୍ତି ସଜନା ଗଛ ଷ୍ଟୋରି କିଛି ଅଲଗା କଥା କହୁଛନ୍ତି ତାହେଲେ ସେଟା କୁହନ୍ତୁ ଆଉ ପ୍ଲାନ୍ କଣ ହବ ସଜନା ଗଛ ଛୁଇଁ ତୋଳା ହବ ତାପରେ ଏମିତି କଣ ଏତେ ପ୍ଲାନ୍ କରିହବନି ପୁରୀରେ ଠିକ ଅଛି ହେଇପାରେ ଅଲଗା କଥା
The overtake, my lords, there are two overtakes. Petition number 1, there was previous enmity between the two families.
That would have been there. They must have been quarreling daily because of the free time.
So while this fight between both the families were going on, petition number 1 handed a stone. That was then hit on the head of the person, the deceased who fell down. Petition number 2 then egged on one of the accused to pick up one wooden stick and hit it on the head of the deceased.
Yes. When I see handing over the sword has been
not so a stick.
Sword, sir.
Stone.
Story which is sword. In the injury report, sir, so blunt weapon is.
That is the wooden lock.
There is exaggeration in FIR. ସଜନା ଗଛ ଡାଳ ଭାଙ୍ଗିଗଲା ପଡୋଶୀଙ୍କର ଗଣ୍ଡଗୋଳ.
But assault was a hard substance.
The learned counsel for the petitioner submits that the petitioner is in nahi agar report ta likhuntu in terms of the earlier order dated 13/11/2023 the learned AGA has obtained instruction regarding the health condition of the petitioner number 1 from the office of the superintendent of district jail Puri through the medical officer district jail Puri which indicates the following with reference to the letter cited above NSAT has been posted to the jail para the copy of the said communication is kept on record. The learned counsel for the petitioner submits that both the petitioners are ladies are in custody since Mr. Das custody since 7/7/2023 and the final prosecution report has been submitted on 30/9/2023. The learned counsel for the informant, the learned counsel for the informant vehemently opposes the prayer for bail, referring to the statements of the certain witnesses recorded under section 161 CRPC before the police. The learned AGA, referring to the case diary, submits that the overtact attributed to the petition number 1 and 2 are that the petition number one, that they provided certain objects to the accused persons to attack the deceased, attack the other side, since it was a group fight between two families, and one of the victims succumbed to the injuries. Se kon hospital le chali gale na spot le chali
Hospital. After 4 days.
The learned counsel for the petitioner submits that though it is not denied, though the person who sustained injuries has passed away, but it was after
4 days.
Administration of treatment for 4 days, and yet the prosecution is to present the case for trial before the learned court. Para. Considering the submissions of the learned counsel for the petitioner, the learned AGA, and the learned counsel for the informant, and the material and record, and the health condition of the petitioner number one, and also the health condition of petitioner number one regarding her advanced stage of pregnancy. The court is inclined to grant bail to the petitioner number 1 and 2, subject to such stringent terms and conditions that will be imposed by the learned court in season of the matter, which shall also contain a condition that any violation of deviation from any of the terms and conditions shall result in filing of petition for cancellation of bail by the investigating agency, disposed of accordingly.
Please.
This copy you are having, Mr. Naik?
I have a copy. Oh, my lords, I'll pray for some time for verification of the documents that have been furnished by the two bailers.
Mr. Das, Rakesh Kumar Das for the petitioner.
Well, see, as per direction of my lordship, I am filing the compulsory affidavit, one of the cousin brother of the patient petitioner and one of the neighbor of the cousin brother. 2 numbers of affidavit I am filing by the direction of my lordship, and also I am handed over the copy of the affidavit to the London State Council.
He's outsider or a?
Yes, my lordship. He's an outsider, but he resided at Sambhalpur. That is cousin brother house.
And he's a cognate or agnate cousin. How he's related?
My lordship, he's a cousin brother. It is uncle's son. Is a cognate son.
Uncle English.
So, the learned counsel for the petitioner refers to that the earlier order dated 10/11/2023 regarding filing of the affidavit by the relatives, affidavit on behalf of the petitioner regarding the sureties. In case the court is inclined to grant bail, the learned AGA submits that he has received copies of the affidavit and may be accommodated further to obtain to verify their credentials and the details. How much time, Mr. Naik?
2 weeks.
जने जो आनिछंती तीन जगह संबलपुर आनिछंती
आज्ञा
संबलपुर कहउछंती त ये कहउछंती वेस्ट बेंगल
नो मालसी द पिटिशनर बिलोंग्स टू वेस्ट बेंगल
हां ताले ठीक अछि संबलपुर आनिबे अपन
संबलपुर affidavit ठीक अछि
कोन लिखले yes the learned counsel for the learned AGA 6 for the time as prayed for by the learned AGA list on आज केते 23 तारिख list on 7 केते हला 23 पर नेक्स्ट डेट हबो के 30 पर 7 तारिख 7
7 Pardon my lordship, if possible that ई मास शेष जाय हितले
देखियो I'll try to get those instructions as
नहीं जदी आसीबो आसिला थोड़ा हम कहि परबिनी but I don't take any somebody who is in custody and whose bail has been rejected by a valid consideration by a court of competent jurisdiction. There can't be any urgency as far as searching for him is concerned.
No, my priority
verification na kemiti hobo it's a process.
One of the coaches person my lords granted bail
I understand,
He's
sir.
an insider.
That I understand, but since he has committed crime outside the jurisdiction, you see, the difficulty is that he would have got ଆପଣ ଏବେ affidavit କେବେ ଦେଲେ 10/11 ରେ ଆପଣ ବେଲ୍ ପିଟିସନ କୋଉ ଦିନ ଫାଇଲ କଲେ
10/11 ମାନେ
31/10 ରେ ଦେଲେ ଠିକ ଅଛି 10 ମାସରେ ଆପଣ ପିଟିସନ କେବେ ଫାଇଲ କଲେ 12/10 ରେ so why you waited for 1 month for prodding by the court so that you should have done earlier ଆପଣ ଭାବିବେ ନା କୋର୍ଟ ଭାବିବେ
My lordship directed, then
there is no direction you must understand how the court can proceed ଆଉ ସମସ୍ତେ ତ କହୁଛନ୍ତି ଆମେ କିଛି କରିନୁ and obviously there is a presumption of innocence ସେଥିରେ କ'ଣ ଅଛି କେତେ କିଲୋ କେଥିରେ
kilo nahi my lordship, it is
Gram.
Corex and
Corex
No,
ଅଛି
100 tablets of
Tablets.
N10 and 12 grams of brown sugar.
12 ଗ୍ରାମ
Nitrazepam, 100 tablets.
ଆପଣ ସେ ମାନେ ପ୍ରେସକ୍ରିପସନ ମେଡିସିନ ଗ୍ରାଜୁଆଲି ୟୁ ଆର୍ ଶିଫ୍ଟିଂ
without prescription
ସେଗୁଡା ତ ଷ୍ଟ୍ରିକ୍ଟଲି ପ୍ରୋହିବିଟ୍ ମାନେ ପ୍ରେସକ୍ରିପସନ ବିନା ପ୍ରେସକ୍ରିପସନ ସେଲ୍ ହେବା କଥା ନା ଆପଣ ବ୍ରାଉନ ସୁଗର ବି କ'ଣ ପ୍ରେସକ୍ରିପସନ ଡ୍ରଗ ହେଲାଣି କି ହେଇନି ଏପର୍ଯ୍ୟନ୍ତ କେତେ ତାରିଖ ଡେଟ୍ କଲେ ଆପଣ
if possible
4 କରିଦିଅନ୍ତୁ ଠିକ ଅଛି ଆପଣ ଯୋଉ ଏକ୍ଜାକ୍ଟଲି କହୁଥିଲେ ସେଦିନ ଆସିନଥିବ ଫେର ଆଇ ୱିଲ୍ ଅଗେନ୍ ଆଡଜର୍ନ because I am not going to because no instruction is there regarding the bailers so ସେଟା କେ ଭାବୁଛନ୍ତି
my
କାଇଁ
lordship director to register to give the direction to London trial court to send the copy
ସମସ୍ତେ ତ ସେ ପିଟିସନଙ୍କ ଇଏରେ ଅଛନ୍ତି at beck and call ଆଉ
my lordship
ଷ୍ଟେଟ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଅଛି ମେସିନାରୀ ରେଜିଷ୍ଟ୍ରି ଅଛି it takes time mister
my lordship
yes
35.
May I please, Lordship?
yes
My lord, on behalf of SK Das,
Saroj Kumar your name sir
Dilip Kumar Sahu, my lord. Sir, for personal difficulty may be placed to Dilip Kumar Sahu, my lord.
Mr. Dilip Kumar Sahu DK Das I'm sorry DK Sahu on behalf of SK Das for the petitioner the London Council for the petitioner seeks accommodation to miss case order karibe as prayed for list on
My next review, my lord.
8th of December 2023 to grant further opportunity to the petitioner.
Oblige, my lord.
36.
Mr. Simpson Jena on behalf of Sarthak Naik for the petitioner. The Learned Counsel for the petitioner, opposite party blank. The Learned Counsel for the petitioner. Six accommodation as prayed for list on 10th January 2024. Name of Mr. Sarthak Naik be indicated in the case brief as well as the cause list.
37.
Yes.
May I please allow me to withdraw the case.
Please file a memo. ଆପଣଙ୍କ power ଅଛି ତ?
On behalf of Mr. Das,
memo ଟା written memo file କରନ୍ତୁନି without power for withdrawal.
power ସାଙ୍କ ସାର୍ signature କରିଛନ୍ତି.
Great. That you should do.
Okay.
On behalf of ତାହେଲେ କାହିଁ କହୁଛନ୍ତି? ଆପଣ yes କହିଥାନ୍ତେ ନା ଆଉ। ଆପଣଙ୍କ power ନାହିଁ ଠିକ ଅଛି। ଆପଣଙ୍କର your name sir?
ସରୋଜ କୁମାର ସ୍ୱାଇଁ.
Saroj Kumar Swain.
ଆଜ୍ଞା.
Mr. SK Swain, proxy counsel on behalf of Sanatan Das for the petitioner. The memo has been memo dated 23/11/2023 is filed by the Learned Counsel for the petitioner seeking to withdraw the petition. The memo is taken on record. The petition the petition stands disposed of. Yes.
38.
Petitioner none. Mr. S.S. Kanungo AGA for the state. None appears for the petitioner when the matter is called. None had appeared when the matter was last taken up on 16/11/2023. And to grant further opportunity to the petitioner, the matter was directed to be listed today. Though the delay was condoned by order dated 11/9/2014 in miscase number 758 of 2013, subject to the petitioner depositing a cost of rupees 250 in the Odisha High Court Bar Association Advocates Welfare Fund within 3 days. And again the said order, and again the time of deposit, kati likhibe, was extended by order dated 11/9/2014. No steps have been taken by the petitioner. No steps have been taken on behalf of the petitioner, not by, on behalf of the petitioner. Apparently, the petitioner has lost interest in prosecuting the matter. The petition stands disposed of. Yes.
39.
May I pleasure, Lordship?
Yes.
This is an application not for condonation of delay. And in fact, today is for the final disposals. And in fact, Lordship, apart from the disposal of that application for condonation of delay,
yes,
now this pertains to a petition filed by the Director of Vigilance Plots in a case on misappropriation. 3 accused persons are there let off by the London trial courts.
Yes.
And with regard to the specific allegation is that there was a surprise check. In fact, the principal diet that is known as District Institute of Education and Training at Calicut.
Yes.
So one of the accused is the principal diet, and he was entrusted with 70,000 rupees. Out of that, he purchased forms and stationeries. And but on physical verification, it was found that stock was not there in that office. The principal took the grounds. Explanation put forth that the stocks could not be brought from the Barampur Cooperative Society. In fact, the purchase was from the Cooperative Society, the forms and stationeries. But subsequently, principal took the ground that due to insistent rain, they have kept such materials at Barampur Wholesale Cooperative Stores. But the Devendra Kumar Das, another accused person, who is the secretary of that corporate society, intimated that he has delivered all the stationery articles to the principal diet. So in these backgrounds, Lordship can see the findings at page.
Das,
my lords.
What is that surprise check? It has authority of law. Some kind of warrant or some kind of.
In fact, the joint surprise was there.
Is it not unusual that
with regard to source
without any search warrant and
Lordship? But in
how that has been dealt with?
No, that was not that plea was neither raised from either of the parties. But the issue was Lordship can turn to the issue. Real issue was framed by London trial court at page 8, paragraph 7 of the impugned judgments. The issue has been framed like this, paragraph 4, whether the accused persons being public servants in furtherance of their common interest. Am I audible to Lordship now? Am I audible to Lordship?
No, सेटा volume crack ହେଲା ବୋଲି ତାକୁ କମେଇ ଦିଆ ହେଇଛି.
Whether the accused persons being public servants in furtherance of the common intention misappropriate the forms and stationery articles.
You are reading paragraph? You are reading
paragraph 4 blocks. That's a issue the London trial courts are framed blocks. The last two line, whether the accused persons being public servants in furtherance of the common intention misappropriate the forms and stationery articles worth rupees 70,000 of diet. Diet, the abbreviation of District Institute of Education and Training, Calicut, which were entrusted to them and could not account for the same, and as such are liable for prosecution. These are the not certain witnesses examined. Let's say can talk to paragraph 5, 7, and last line of paragraph 5 is 7 and 8 are the IOs, my lords.
Yes.
And my lord, with regard to the exact finding as para 6, no materials against the Devendra Kumar Das. He is the accused number 2, my lord. Opposite partner 2 is the secretary of that cooperative society from whom the principal purchased all those stationery items, my lords. And about if lordship get on to last line.
Para 8.
No, para 6.
Sorry, page 8 overwritten. Maybe it is
para 6 is the
page 14. Page 14, running page 14. Internal page 8 of the judgment. 14 is marked in the right hand top corner. That is internal page 8 of the judgment. That fact has been there in the case diary. It reads, not a single witness. Is it correct? No witness.
Now, in fact, PW 1 and 2, the staffs of the cooperative society, they have stated specifically that after the sale, the articles were delivered to the purchaser as the principal.
No, you see that is a. I mean, they are DWs now.
And now, in fact,
but it is also not a single witness, including, or it is just a very strong statement by the court, or it is a fact. Not a single witness, including the investigating officer or the informant who inquired into the matter regarding misappropriation of the fund, has made such allegation in any corner of the evidence.
Correct.
It is not there.
No, not there. Now, in fact, there are two.
They say that yes, it was delivered. So the allegation is that though they sold the purchase, but there was no actual indent of the no receipt of the stock.
It was told and it was given to the principals. But in the surprise check, it was found as stock. There are some shortages, my lord. But it was there, in fact. And secondly, my lord, no sanction could be obtained. That is one of the reasons, my lord.
Sanction regarding the Secretary Cooperative Society, he has
not obtained.
But regarding principal, also not obtained.
No, that was not there. But the another opposite partner one, he is the clerk of the diet, my lords. So he was practically. He was roped because he was assisting the principal mods. But there is no such a cause and materials on that.
First of all, the principal allegation has to be proved. Then whether clerk will be held responsible, that is another aspect.
Correct, but he is tagged on that. But if lordship permits, my perception about that, all the evidence, my lords. But in fact, this is about the shortage of the materials.
Actually, when it started, perhaps
materials were purchased and it was sent to the
without any basis. Search there could have been an audit.
Yeah, lordship is cleansing the issue, my lords.
Audit, maybe there was an audit, there was a report, then there was investigation.
The persons who sold, he said that I have sent to the diet, and the persons who kept that was there. But in the surprise search and all these things, lords.
Have you prepared the matter?
Your lordship, actually we don't have the CRLLP copy, your lordship. So they have not served.
Oh, I'm sorry. He's the opposite party.
Yes,
I didn't realize that. I admit that I delay condone.
Yes, sir. Your lordship, the delays of 460 days, your lordship. And your lordship, it is
no, since delay already Mr. Das has argued certain matters.
Yes.
So he's not repeating his arguments.
Yes, lordship.
Because in fact the delay is not satisfactorily explained.
Yes,
if one applies the principles laid by the Supreme Court, each day's delay has to be explained, so that he's not reiterating his submissions.
Yes, your lordship.
The IA likhibe. IA so and so along with this is item 39. CRLLP 46 of 2014. Miscase 30 of 2014. Mr. Standing Counsel, S. Das Standing Counsel, Mr. Apanaka na sir?
Sir Pritam Pradhan appearing
Mr.
on behalf
Pritam
of
Pradhan,
Ms. G. Patra.
On behalf of Mr. Miss G. Patra. MS.G. Patra. Gayatri Patra. The learned Standing Counsel submits that in the petition Stamp reported submits that though it has been mentioned in the petition for condonation of delay that 55 days delay has been caused, but inadvertently the same is a mistake. The said fact is due to inadvertence, whereas the actual delay is of 468 days. Having considered the reasons shown in the petition for condoning the delay, in considered opinion of this court, no sufficient reasons have been shown for condoning the delay of 468 days. And in any event, the petition was filed explaining the delay of 55 days. Para. The court is not inclined to grant to condone the delay in filing the petition. And the miscase is dismissed. Para. Apart from not condoning the delay, this court has also considered the matter in the context whether leave can be granted for appeal as sought for in the petition under section so and so of CRPC. Para. On perusal of the judgment rendered by the trial court.
Lordship, may I disturb?
Yes.
Under section 13(2), read section 13(1)(c) of the Prevention Corruption Act and under section 490/34 IPC.
No, leave kuthre hoschigi CRPC re na.
Yes.
Leave is CRPC.
Yes. We are filing application.
So that paragraph
378.
Then that first paragraph I am leaving.
Yes.
Because
leave is filed on section 378.
Yes. So first paragraph likhi debe. The petition has been filed under so and so CRPC, seeking leave against the order of acquittal passed by the so and so in case number so and so, acquitting the opposite parties from the charges under section 13(2) read with 13 into bracket 1 into bracket small c of the Prevention of Corruption Act, 1988. And under section 409/34 IPC. This court has Yes. Judgment rendered by the learned trial court is indicated that sanction for prosecution was not obtained for the
opposite
party number 2, and a further finding has been returned after appreciation of the evidence presented by the prosecution, particularly the two investigating officers, PW 7 and 8.
7 and 8.
PW 7 and 8. That regarding the fact that not a single witness, including the investigating officer or the informant who inquired into the matter regarding misappropriation of fund,
they could not put forth
tendered any evidence to substantiate the charge.
Charge of misappropriation.
Apart from the case diary, no further evidence was adduced to substantiate the allegation. It is further noticed by the learned trial court that PWs 1 and 2, the staff of the cooperative society, specifically stated that after the sale, the articles were delivered to the purchaser the
to the diet.
to the principal DIET into DIET full form hochi
District
Institute of
District
Education
Institute
Training.
of Training is.
Regarding the Mr. Patnaik, Prabhesh Patnaik is OP3.
Yes.
Regarding OP3, the learned trial court arrived at a conclusion that he being a subordinate staff, he was not directly implicated.
No, the
And
clerk, the clerk
allegation
is,
against the
clerk is OP1.
OP1, OP3 tak 1 kar diyo. And the allegations against the higher officers could not be substantiated in the trial. But in view of such findings given by the learned trial court, in contrary opinion of this court, the present case is not fit for grant of leave to appeal and it stands disposed of. ଆପଣଙ୍କ ନାଁଟା ସାର୍ କଣ ଲେଖିଲେ ଲେଖା ହେଇଛି ନା? Yes.
Much obliged.
Yes, please.
Item 30.
My lord, I humbly pray for adjournment. 2 weeks time.
You are Mr. Pradhan.
I am Mr. Sarveshwar Pushti.
Mr. S. Pushti.
My
You
lord.
have power here. Mr. S. Dot Pushti. Mr. S. Pushti for the petitioner. Mr. Satyasundar Kanungo for the opposite AGA for the opposite party. The learned counsel for the petitioner seeks accommodation. Order से कौन पे आछी आया? अपन देखी ना थी.
हाँ ये इधर
आईएटर ए continuation of
interim order
2014 order. केबे फाइल कले?
2013.
Again 2/3/2015 पर्यंत continue.
After ASEAN resurfacing twice considered by Supreme Court, can it be done? ଆପଣ 23 ମସିହାରେ ଯୋଉଟା ଫାଇଲ କରୁଛନ୍ତି on the face of it itself has to be rejected. ଯଦି ଆପଣଙ୍କର ପେଣ୍ଡିଂ ଆଇଏଟା ଥାନ୍ତା then you would have a case. କାହିଁ ଏଗୁଡ଼ା କରୁଛନ୍ତି? Because you are inviting a order indicating vacation of interim order. You must understand, have a strategy in your clear strategy in your mind. You see, there is an interim order, not extended. The other side has not done anything, or there is no order vacating that order. ଆପଣ ଗୋଟେ ଆଇଏ ଫାଇଲ କାହିଁ କରୁଛନ୍ତି ତା ଦେହରେ? After 10 years, 9 years. You must understand the consequence. This IA cannot be entertained. It has to be dismissed.
2 weeks after us.
Press for accommodation as prayed for list on 18 December or January.
January 1st.
January कर दो.
5
पण सब जगह फास्ट वीक रे कोन रखछन्ती 4 5 तो ता छडा डेट ही दोनांती आपण आज 10 1 20 23 20 I'm sorry मु गोटे वर्ष पछु पळिली 2024 yes
41
21 20 21
10 1
41
My lord, 1 week time for clearing the defects.
Limitation in the step.
Yes.
The limitation runs till date.
My lord, 1 week time may be granted.
ଆପଣଙ୍କ ନାଁ sir?
Siddhant Mohan Patnaik.
Mr. Siddhanta Mohan Patnaik is
On behalf of Mr. Umesh Patnaik.
Mr. Umesh Patnaik for the petitioner. The learned counsel for the petitioner submits that due to inadvertence, the defects as pointed by the SR could not be removed and the steps for limitation could not be taken. He seeks further time to do the needful. As prayed for further 3 weeks time granted.
Obligation.
42
My lord, 42.
Unserved notice कौन करिया?
Again, my lord, delay was condoned on 1/3/17.
But without notice तो ହେଇପାରିବନି.
ହେଇଛି ବୋଲି କି ଟିକେ
ମୁଁ ଦେଖୁଛି I'm just checking.
ଆଜ୍ଞା
1317 कहउचंती इश्यू नोटिस
My lord, so far as
so state may be, but 2 and 3 they are private opposite party.
yes, 2 and 3, my lord, I have
Unserved notice is there.
no, I have given the address PS Tikabali and whether the notice has gone to that place or notice, my lord.
Hey, आपन postal रे दरकार नहीं police station correct,
Agya.
किंतु such address is not under Bell of other branch of
Bell of other तो से किछि
तले आपण present correct address दे दियंतु. I am giving sufficient time, as you know, the reason being because again and again these matters are listed for orders. 4 weeks time नियंतु, but try to obtain something जोटा कि it can work out. देखंतु आईए रे लिखिबे. This is item 42. आईए रे नंबर टा किछि पडिनी. मोर लिस्ट रे भी कोन लिखा हैला. से जहाँ भी मिसकेस नंबर तो लिखिबे ना सेटा जज बाहर करिवे. मिसकेस नंबर 69 of 2016. आपण you have to train them. आपण जुबने के समस्त को नुआ पिला आछन कहिबे. Because once we see the cause list, we think that there is no miscase. Miscase 69 of 2016. By order dated 1/3/2017, notices were issued to the opposite parties 2 and 3 by registered post with AD. The learned counsel for the petitioner submits that appearance liquid Mr. Sujata Janna for the petitioner, Mr. S.S. Kanungo AGA for the OP1. The learned counsel for the petitioner submits that notices were taken in the available address as provided, as indicated in the lower court judgment.
Yes.
As indicated in the lower court judgment. Because no, it should on 9/3/17. जो ऑफिस नोट गुड़ाक कौन ऑर्डर शीट मझे रही पेज एपट सेपट हो गला ना कौन मु तो आपण को 4 ही देखंतु ऑफिस नोट 4 ही ता पूर्वरु मोर ऑर्डर अछि ऑर्डर नंबर 5 11 10 ता पूर्वरु ऑफिस नोट ऑर्डर नंबर 4 office note dated 10/10/2023 photo by the registry indicates that limitation notice issued to the OP number 2 and 3 are returned unserved with postal endorsement quote such addressee not under Bella Padar branch office hence returned to the sender. The said note the they don't stop कर दियंतु तापर सपारा करंतु the learned counsel for the petitioner seeks leave to take notice afresh to the opposite parties 2 and 3 para prayer is allowed, let notice be issued to the opposite party number 2 and 3 afresh. Requisites for issuance of such notice be filed within 4 weeks in the present correct address. Unutilized requisites comma if any shall be utilized.
Obliged.
On filing of the requisites, the registry shall do well to issue notice to the opposite parties 2 and 3. Yes, Mr. Misra.
In this case, so the respondent number 2 already died. That's for
Lordship already the respondent number 2 has died. In the meantime,
on
today we are filing the death certificate and along with memo.
But since it is a hospital, so आपण तांकु एटा कोन इंडिविजुअल लायबिलिटी करथिले?
No, first was the hospital as well as the
केमती क्रिमिनल लायबिलिटी केमती फैशन हबो मो सेटा पचार छ आपण हॉस्पिटल ले क्रिमिनल लायबिलिटी केमती प्रोसिक्यूशन हबो
hospital you receive as per the biomedical EPA
contractual नो बर्तन तो आपण जहा को भी करिवे how he will be arraigned as an accused Violation of pollution norm ठीक अछि.
So 50,000 fine each to the hospital. As per the conviction, the trial code, 50,000
Stay
fine.
ହେଇଥିବ.
And the respondent number 2, 6 months imprisonment with fine.
So it abates.
Sit abet. 8 of 1 pay I will.
1 ପାଇଁ କେମିତି ହବ?
1 pay to different thing. 50,000 fine only.
ନାଇଁ ମୁଁ 1 ପାଇଁ ତ କେବେ ହେଲେ ମତେ କାଇଁ ଲାଗୁନି ଆପଣ ଯୋଉଟା କନସେପ୍ଟ କହୁଛନ୍ତି ଯେ ଗୋଟେ ଆପଣ ଇନଷ୍ଟିଟ୍ୟୁସନ को फाइन କରିଦେଲେ କ୍ରିମିନାଲ ଲାୟବିଲିଟି कंपनी ना कोन
नहीं हॉस्पिटल
कंपनी रे ही परिबो बट एतरे हॉस्पिटल ले कोनटा
हॉस्पिटल भी हे परिबो एटा बायोमेडिकल वेस्ट मैनेजमेंट रूल्स रे होची बायोमेडिकल वेस्ट मैनेजमेंट एवरी हॉस्पिटल हैज टू adhere to the rule if they violated section 15 of the 19 of the EP Act they will proceed.
हॉस्पिटल डिपेंडेंट काउंसिल किए थिले
डिपेंडेंट काउंसिल
कटक रे जो चलथिला आपनकर आपन तो सेतो थिले पोल्यूशन कंट्रोल बोर्ड रे
सेटा मु तो थिली जे सेटा स्टेट काउंसिल थिबे ना से
किए थिले
मु कहि पे सेटा नवरंगपुर एटा बोलते सर जगतसिंहपुर
ठीक है
जगतसिंहपुर
हां जे आपण
एटा एबेट करियो यू लॉसिप पुट इज नेक्स्ट वीक आई विल सैटिस्फाई 2 पे एबेट करियो
लिमिटेशन कोन कंडोन कर दवा डिले आपण आपण ना रिप्लाई देबे कहितले दे नांती
no sir your lordship said I will hear on merit I have already given the delay condonation petition
आपण
lordship
मेरिट रे देबे रिप्लाई आपण गोटे टाइम नै थिले
in necessary
Mr. for the petitioner Mr. आपण को ना सर पीपी बारिक
not I am Barik I am DS Panda on behalf of
Suvi SB Panda
lordship
Subha Vikas Panda for the OP number 2 OP 1 को ପାଇଁ की अपेयर करिवे स्टेट अपेयर करिवे लॉर्डशिप अपेयर करिवे
ना lordship
but you answer
necessary lordship kindly necessary orders
coincidentally you answered this query I was asking Mr. Mishra who was appearing for the earlier for SCB Medical College in PIL. So that you answered. But here I cannot appear. The district headquarter hospital obviously आपण तो notice ना पड़ो कहा को notice नेबे. But आपण जो क्वेश्चन जे individual liability नो एटा hospital liability एटा केमति हबो अपने केमति the concept is very difficult to understand.
So your lordship will put it next week explain.
नहीं केबे आसीबे सेटा अलगा कथा. कोन लिखले ओपी नंबर 1 ब्लैंक कर दियंतु नोटिस जाइतिला ओपी नंबर 1 को अपन देइतिले मिस्टर मिश्रा
जाइतिला सर नोटिस जाइ एडवोकेट की अछि कि 2 पे 2 1 टाइम भी अपन
25 11 रे बोते नोटिस हेतला 25 11 10
यस
ए 10 को 16 सॉरी भूल
16 स्पीड पोस्टर कोन हला तापरे मिस्टर मिश्रा
कांट से सो फॉर द 2 इज
पण हॉस्पिटल ले नोटिस पठेले की रिसीव करिवो
सीडीएमओ थिले सीडीएमओ
कोट आपण को काकू तो पार्टी करना आपण को मते से तो आपण पचार जे आपण हॉस्पिटल जो पार्टी करचंदी एडीएम को पार्टी कर देले एडीएम अपियर करले बट ही आई डोंट थिंक एडीएम कैन अपियर सीडीएम एंड पीएचओ वेदर ही कैन रिप्रेजेंट द
हॉस्पिटल हु वाज इन चार्ज एट दैट टाइम
आपण हॉस्पिटल ले जब डीटा पार्ट टेंशन तो जो सुपरिटेंडेंट थांती से जी लुक्स आफ्टर द हॉस्पिटल एडमिनिस्ट्रेशन
It is the ADMO. He is the ADMO here.
ADM तो चली गले.
ADM चली गले हाँ चली.
हाँ तापर तंक नोटिस केम दिने बे.
Now at present who is this CDMO? We have to examine it.
How it will be transmitted मो बुझी पाने. आपण क्वेश्चन जे it is a माने continuing cause जोटा कि like कार मेटा कौन state. परंतु आपण कर ए प्रकार suppose a person against whom like PC Act is pending.
Yes sir.
There is a proceeding for recovery and confiscation. In that proceeding, you can array the legal hairs. But hospital पर केमती legal hair आपण कहउचंती next in person. You see how you are fastening the knowledge of this crime to this particular present ADMO or CDMO?
No. Individual person who has been alleged as a occupier, he died. Now, my lord, respondent number 2.
सेटा काइन डिस्कस करछन. So far the problem होची आपण जोटा कहउचंती पण ସେଟା ସେ ବହିଟା ଆଣିକି ମତେ ଦେଖାନ୍ତୁ.
हाँ देखिए next to
Sir,
your
the learned counsel for the petitioner submits that as per the instructions, the OP number 2 has passed away in the meantime. The learned counsel for the OP number 2 produces memo
with
along with enclosing
death
a certificate
with memo.
certificate issued by the appropriate authority indicating the said fact, indicating the fact of demise of the opposite party number 2. In view of the above, the petition stands abated as far as OP number 2. Regarding OP number 1, since there is no indication of notice being sufficient on OP number 1, the learned counsel for the petitioner shall obtain specific instruction. Party Kardila district headquarter hospital represented through the then ADMO.
Yes, ADMO.
Language then. How he will be, who was in 20 years back, ADMO was there. How he can represent today in appeal?
No, sir, now he cannot because he already.
So, but you have made him party. Upon the petition, it's very difficult. Upon it's a criminal liability. Upon it is very difficult to appreciate. Specific instruction and advance arguments as prayed for. Mr. Misra?
Lordship put in next
January.
January
After vacation. Yes. Ninth of January 2024. The memo is kept taken on record. Miscase रे कले तो order टा 117 of 2016. Yes.
44. Item 44 टा adjourn कर दो तो 2024. Kindly January or February.
Mr. এটা খালি IA ପାଇଁ ଆସିଛି.
এটা খালি cancellation ମୋର ନା ଏଟା ମୋର ମାନେ state file କରିଛି.
ये भी ଅଛନ୍ତି ନା he is in custody or
ନା custody.
He is in custody. So no effective order is there.
ଆଜ୍ଞା ଗୋଟେ ସେକେଣ୍ଡ ଏଇ custody ନା ବାହାରେ custody ହଁ ନାସା ରେ NSA ରେ ଅଛି ଭିତରେ
ତାହେଲେ ଏଟା maintainable ହବ. NSA that is preventive, not punitive.
Preventive detention.
NSA 2 years ago, so must have been released in the meantime. So NSA maximum.
तेबे मु press करेगा था.
Maximum.
Then I need to press it.
1 year, 3 months extension. Must have been released. Then he was arrested in 2019. Bail was granted in 18. He was arrested in 19. Now it is.
Yes, what you say, the subsequent paragraph 4 re jota. Yes, capital PS case number 413 has been registered.
Correct.
What can be your answer there?
No. They are questioning the bail granted by this honorable court. Paragraph 4, which they say, my lord, that here their entire case is that your lordship will see paragraph 6.
I want cancellation of bail, my lord, granted in bail number 9043 of 17.
Yes.
On 24/18. Certain conditions were put there, my lord.
No, you also obtain, no, there will be confusion. Because that bail is not valid for the subsequent offense. Because I think I discussed this last time. You are not there.
That bail is pertaining to a case which was committed prior to the subsequent registration of cases.
So in the subsequent case, is it a non-bailable or a bailable offense? So he can be arrested.
He was
arrested.
Subsequent case.
Yes. But his arrest itself indicates that he clearly flouted the conditions given in earlier bail application, my lord. That is clearly indicated in paragraph 2.
Then what happened to this original case?
Original case is pending.
Good. Pending for trial.
Trial. It is
Cancellation.
pending in trial.
My lord, cancellation was sought for only on another ground, my lord. Ground is while one witness, my lord, was not examined.
Paragraph
he
6,
was,
your
he
lordship,
was
may kindly say.
shown that he has been examined before this honorable court, and for which the honorable court held that since
that vital witness has been examined.
Yes.
Paragraph 6 is the
Because that was the
crux of the case.
That was the foundation for granting the bail.
Yes. And another ground is, my lord, while on bail, my lord, he committed another.
So you are reading that affidavit by the sub-inspector of police
Ramahari Sethi,
that is dated 19/11/2020.
Correct, ma'am.
But that affidavit has not been given to me.
No, that
Not given to you?
that is the only affidavit actually.
It is the only affidavit I believe in the brief.
No, except the CRLMA petition.
So that is how actually your submissions are not matching with their submission.
Yes.
So in fact, what you are saying,
Your
paragraph
lordship may kindly see page 6 of the CRLMA petition.
no, why I'll go to that CRLM?
Well, that is the ground of seeking cancellation of bail.
No. The ground of is in another petition has been filed in the form of an affidavit.
Well, that has not been served on me.
So, my lord, I undertake to serve a copy today, right now, and my lord may conveniently call it any day next week.
Yes. No, but you also obtain up-to-date instruction regarding the present status. Because now exactly 3 years have passed.
Correct, my lord.
So, since he's a history sheeter, how many instances he would have been arrested in which case, what has happened, and what happened to this particular trial? Suppose in this particular trial he has been acquitted or convicted.
Will your lordship be kind enough to consider my small prayer, my lord? With regard
Yes.
to that, can that information through the honorable registry of this honorable court, my lord, be called
No,
for?
it's very difficult because I have not myself understood. Mr. Kanungo, the difficulty is that suppose this trial has ended up in conviction, then the entire process of bail is frustrated.
That goes. Entire brief goes.
So obviously, so then there is no point in granting, because after conviction he has been again sent back to custody.
He must have been.
Obviously. And if he is granted bail in the appeal, then also this
survives.
This fails.
This
because there is
fails on
another
the-
proceeding altogether.
No, sorry, this fails because
439
this fails.
So if I have understood it, 439
Within the ambit of bail cancellation.
439 once he is convicted has no meaning.
Yes.
Once he is convicted, he has to file that appeal, and appeal le jo provision da achi file kare.
That will not apply to this.
So this has
in
to,
any case will go.
Disposal of the trial, that will be not.
Completion of
that
trial
is only
cancellation na abasyakata nahi.
No, abasyakata.
Suppose he is acquitted, then also it cannot be granted because he has already granted.
Because he faced the trial.
Yes, he faced the trial and got
So
acquitted.
this cancellation also.
So let us, you obtain instruction also and serve a copy.
Agya, हाँ. Oh.
ଆପଣ କଣ ଡରିକି ଏଗୁଡ଼ା କରୁଛନ୍ତି ନା ନାଇଁ ଭଲରେ କରୁଛନ୍ତି?
ନା ମୁଁ ବେଲଟା କରୁଥିଲି ତ ସାର୍।
ହଁ ଯେ ସେଇଟା କଣ ବେଲଟା ଡରିକି କରୁଥିଲେ ନା ନାଇଁ ଭଲରେ କରୁଥିଲେ?
ଆଜ୍ଞା କିଛି
043 of 2017 shall be solved from the learned counsel for the petitioner during course of the day to enable him to obtain instruction.
Correct.
ତା ପୂର୍ବରୁ ଲେଖିବେ ଫାର୍ଷ୍ଟ ପାରାଟା ମୁଁ ଛାଡ଼ିଦେଲି। An affidavit has been filed on behalf of the investigating agency for cancellation of bail by this court by order dated 24/2018 in BLA appeal number 9043 of 2017. ତାପରେ ଏଟା ଲେଖିଦେବେ। Here the paragraph 6 is only that my fact stated about true to my knowledge based on official records. You are referring to the CRLMA.
Yes.
So CRLMA is not the subject matter here. It is only for cancellation of bail as far as this court is concerned.
It is only cancellation. I will hand over this copy.
Yes.
I would have देखी
Para. The learned AGA submits that he may be permitted to obtain instruction as the petition was filed on 19/11/2020 based on the obtaining facts and situation, and he has to obtain up-to-date instruction regarding the status of the case, out of which the BLAPL 9043 of 2017 arose. Pertaining to CRL .tr. number 118 of 2011, arising out of number term 9043 yes. Lingaraj PS case number 59 of 2010, pending in the Court of Learned Additional Session Judge, Bhubaneswar. Yes. List on January कर दबा
again
January date कर दियो 17/1/2024
ଆଜ୍ଞା ମତେ ଦେଇ ଦଉଛନ୍ତି ସାଙ୍ଗେ ସାଙ୍ଗେ ଦଉଛି ଆପଣଙ୍କୁ ନଦେଲେ ଉପାୟ ଅଛି ସେଠୁ
45. I have purposefully mentioned the case details, Mr. Kanungo and Mr.
Again.
Bose, because you also do not know what has happened in that case.
My lord, I have no contact with the client also.
Let us.
And it is better not to call those persons.
Yes. No, Justice Prasad actually asked for his presence. He was
once
seen
his personal attendance was sought
twice,
for,
thrice I have
he
seen him
came being heavily guarded by police personnel. I remember that.
in the new building.
Yes. And he also was offered a chance, my lord, to have communication with the Honorable Court. I was there, physically present, though I was there.
Justice Prasad was actually comes from a chamber of prolific criminal practice, tremendous knowledge and as you know, Uttar Pradesh.
Basically, because
my lord, on those days were much rough.
He has.
It's not an application. That is, this case is pending so long.
You are Mr. S.K. Mahapatra?
No, Das Naik.
Das Naik.
Radharaman Das Naik.
Mr. Radharaman Das Naik for the petitioner. But ଆପଣଙ୍କ ନାଁଟା ଏଥିରେ କ'ଣ R ନାୟକ ଲେଖା ହେଇଛି? ଆପଣଙ୍କର CA କେ ଦାସ ଅଛି ନା, ଆପଣ ଗୋଟେ ଲମ୍ବେଇକି ଲେଖିବା।
ହଁ, ଚୌଧୁରୀ ଅସିଂହ ଦାସ ଏକେ ଦାସ।
ସୋ ଆପଣ RRD ନାୟକ କରିଦିଅନ୍ତୁ।
ନା RD ନାୟକ ଚାଲିଛି କୋଉଠି?
RRD କଲେ
R ଦାସ ନାୟକ ଲାଗି ଚାଲିଛି। R ଦାସ ନାୟକ।
Radharaman Das Naik for the petitioner, Mr. SS Kanungo AGA for the state. Modification କାହିଁ ଚାହୁଁଛନ୍ତି? ସେଟା ମୁଁ ପାସ୍ କରିଥିଲି ଅର୍ଡରଟା।
ପୁରୁଣା ବହୁତ order by Justice I Mahanti, my lord.
Great shoes to fill up. I cannot fill up the big shoes. कौन order modification हवा दरकार फिर आपण
बेल डाला ହେଇଥିଲା डायरेक्शन
12 ରେ फाइल कले 23 रे टेक ऑफ ହେଲା बढ़िया
आरे ହେଇଥିଲା जे लेखिस पेज 2 रे लेखिस मिसकेस रे the release the petition on bail with the condition that he shall appear before the IAC.
एटा आपनकर सर्वाइव करन थियो आपण इंस्ट्रक्शन नियंत बेल कंडीशन आउ 12 वर्ष पर सर्वाइव करिवो पण ट्रायल सरी अपील सरी बणी ये पूर्ण आप जस्ट पूर्व मैटर भले आइ गला
ऑर्डर किछ लाभ होबनी
किछ लाभ होबनी आपण इंस्ट्रक्शन दियंतु आई एम नॉट टेक इंस्ट्रक्शन MC 1197 of 2012. The miscase has been filed for the modification of order dated 4/2/2011, passed earlier by this court. The prayer made in the petition is for modification of a condition of bail regarding appearance of the petitioner before the police station of the jurisdiction. In view of the lapse of 11 years, the learned counsel for the petitioner shall obtain up-to-date instructions in the matter as to whether anything survives at present for adjudication. केबे चाहुचंदी?
2 weeks पर आसो
लिस्ट माने 11 जो वीक रे ना 18 वीक रे आसीबो डिसेंबर रे
डिसेंबर सर
डिसेंबर दले 19 तारिख 19/12
48
Mr. Pradhan was present, but the bail condition modification.
এটা 48 ଆପଣଙ୍କର 49
ଆପଣଙ୍କ ପାଖରେ କପି ଅଛି?
ନାଇଁ କପି କୋଉଥିରେ ବି ନାହିଁ ଆଜ୍ଞା ଦେଇନା
This case 69 of 2013 ଲେଖନ୍ତୁ। Arising out of ଲେଖିବେ ବୁଝିଲେ ଉପରେ ଲେଖିବେ arising out of so and so ଯାହା ଲେଖିବା କଥା ଲେଖିବେ। The petition has been filed for modification of the order dated 7/11/2012 passed by this court to the extent to modify the condition of deposit of cash security. Para. None appears for the petitioner when the matter is called. In considered opinion of this court, after a lapse of 11 years, more than 11 years, nothing would survive for adjudication. The miscase stands disposed of. ଆପଣଙ୍କର ଯୋଉ ବେଲ୍ କଣ୍ଡିସନ ମଡିଫିକେସନ କପି ଦେଇଛନ୍ତି?
You have given a copy to the previous counsel, Mr. Kotkia was appearing. Anyhow, my lord, today in course of the day, I will serve a second copy.
এটা କଣ ମଡିଫିକେସନ ହବ? 3, 4, 6 এটা ଯୋଉ କୋର୍ଟରେ ହେଇଥିଲା ସେଠି କଣ available ନାହିଁ ସେ ବେଞ୍ଚ?
My lord, Justice C.R. Das has been.
ଆଚ୍ଛା।
And in the meantime, for about last 6 years has been passed.
ଆପଣ କଲିକତାରେ ମୁଭ୍ କରୁନାହାନ୍ତି କଣ ଅସୁବିଧା?
If my lord gives the proper.
ସେଟା ତ ମୁଁ ଦେଇପାରିବିନି ମୋ jurisdiction ନାହିଁ ତାଙ୍କର ଅଛି।
And second ଅଛି about second
ପିଟିସନର ଯାଇକି ମୁଭ୍ କରିବେ ନା ପିଟିସନର ତ ଯାଆନ୍ତି ସେ ତ
ପିଟିସନର ଯିବ
ମୋବାଇଲ ସୁଟ୍ କରିବେ।
ପିଟିସନର କାଉନସିଲ ବି ଯିବ ସର ଯେ 2 and 4 arrangement ହେଇଗଲେ 2 and 4 arrangement ହେଇଗଲେ ସବୁ
ସିଏ କରିବେ।
some sort of order will meet the purpose.
ଆମର ତ ନାହିଁ jurisdiction ନା କଣ କରିବେ?
Here what has happened, the condition which has been passed about 6 years.
That idea, what is there? ସେ କଲିକତାରେ କଣ ଦଉନାହାନ୍ତି କି ପ୍ରବଚନ?
କଲିକତା ସେ ପ୍ରବଚନ ଦ୍ୱାରା ସେ ଓଡିଶା ପାଇଁ ଲିମିଟେଡ ଟୁ ଓଡିଶା।
ଆମ ଧରା ହେଇଥିଲେ କଲିକତାରୁ ଦଉନାହାନ୍ତି।
ହାଇଦ୍ରାବାଦ
ବାଙ୍ଗାଲୋର
No, absolutely not. He has been caught red-handed from the ashram of Kendrapada. Three allegations
ଫେରିଲା ପରେ
ଆଜ୍ଞା
ଫେରିଲା ପରେ ସେ
ରାଇଟ
ଓହୋ ଆଚ୍ଛା
ଫେରିଲା 1.5 ମାସ 2 ମାସ ପରେ allegation
ସେଥିରେ କଣ ଡିଫିକଲ୍ଟି କଣ ହଉଛି କି 3, 4 ରାତି ଆପଣ ଠିକ ଅଛି ଇନଷ୍ଟ୍ରକ୍ସନ ନିଅନ୍ତୁ।
ହଁ ମତେ ଗୋଟେ କପି
ସାଙ୍ଗେ ଦେଉଛି ଇନ କୋର୍ସ।
ସେ ମେ ବି ତା ବ୍ରିଫ ରେ କପି ନଥିବ ସେଟା ପ୍ରୋବ୍ଲେମ।
ଟୋଟାଲ ବ୍ରିଫ ଟା
ସାଙ୍ଗେ within 5 minutes I'm giving. मेन केस है आईआर कॉपी को दिया
आईआर कॉपी दे
IA 471 of 2023, Mr. Manas Chan for the petitioner, Mr. SS Kanungo AGA for that item 49 election. Mr. For the AGA state, the learned counsel for the state seeks for another copy of the petition. The learned counsel for the petitioner
in course
of copy of the same within 2 days. Within 2 days. नहीं अपन एबे देख
send it.
ना मालूम कौन होची की प्रॉब्लम होची अगेन एवडा ऑर्डर से के आउथरे आछी
आगे ठीक अछि
2 days. The learned AGA shall obtain instructions in the matter. केबे आसीबो
1 week 2 weeks after
एटा 2 week पर आसो अपन
हां आसो
as prayed for
second week of December
list on 12 नहीं कंडीशन टा कोन असुविधा होची तो भलरे अछंती कोन चलची ना
नहीं भलो नै दीटा तीनटा कंडीशन पे मैं अवॉइड करछि गोटे होची जे क्राइम ब्रांच को प्रति डेट रे जीवा पर व्हेन यू विल गो आउटसाइड he has to give indication with intimation to the concerned crime branch of officers. They will give a permission, thereafter he has to go. So gote permission. In the meantime 6 years have been passed and he had been to outside for about 5 to 6 or 10 occasions, about 10 to 12 occasions. All the times he has to go, he has to apply, the authorities will scrutinize it and they will utilize their office this way, that way. 4 days, 5 days thereafter they are giving the permission. So by this process, my humble submission is because of the fact that he is not going outside the country. So this condition can be wiped out to this extent that whenever he will go out, he will not leave the India.
पासपोर्ट सरेंडर करना थी
पासपोर्ट नहीं है
एफिडेविट देछन नहीं बोली
नहीं पासपोर्ट नहीं whenever he is going outside
छटा कोन
आउट दिटा कंडीशन अछि जे appearance for the proper appearance before the court and this honorable court has also married basically the last order this honorable court has also directed that whenever he has to appear before the concerned court
एटा की कंडीशन आपण कोन असुविधा हो आपण तो निजे कहउछन 6 वर्ष रे 6 थर से एटलीस्ट आसी आपण गोटे देखिबे एसआर बोमे रे गोटे लाइन अछि एसआर बोमे रे गोटे लाइन अछि सेटा मु केतले भाबुतली आई वाज इन फैक्ट appearing for in all these matters for municipality. But good mandap hi ni. So that there was a question as a whether mandap can be state donate kari paribo ki nahi. Mandira, I'm sorry, mandira, masjid, girja jaha pai. But say jaga re gote SR bomber gote line achi se jo ye re. I think sithire achi je that state has no role. ଆପଣ ଗୋଟେ ଆପଣ ଆଭୋକେସନ ରେ କଣ ରେଷ୍ଟ୍ରିକ୍ସନ ଅଛି ଦେଖେଇବେ ନା ପ୍ରଚାର ପାଇଁ ଯଦି ସେ ମନା କଲେ ଆପଣ
ପ୍ରଚାର ସାଙ୍ଗେ ନୁହେଁ ଆମେ that is my only source of on the relevant day Malad has put me a question while granting bail. Mr. Chan, from your side you give whatever condition you want to take and thereafter it will be considered. So it is me who has
it's a very difficult ଆପଣ ଦେଖନ୍ତୁ I don't think
because that was the only activity in terms by
तापर आपण जदी जो right to liberty individual liberty तो एटा डायरेक्ट कर्टेल करछि ना आपनकर freedom of speech. So then whether freedom of speech amounts to religious preaching, yes, I don't think. I'll try my best to satisfy the second condition. आपण you are not showing anything. Perhaps I should not now comment on जेतु discussion हेई गला सेत पे मु कहि देली आपनकर काम करिया रे कोन असुविधा अछि आपण you lead a normal life.
My humble submission, this honorable court also the next condition while wiping out this condition has allowed us to maximum people of 200. Well, may see the order. Next order. It was this order was
that was in the media. That was in the media.
No, my lord, no.
See, colony will have because he's a very well discussed person, much discussed.
No, my humble
submission. Say, कौन no kale.
On 4/8/2017, this honorable court has passed this order. Subsequently, in the next order,
से बढ़ेले 200 लोग maximum है.
200 लोग कर देले. So my
एबे आपण केते लोग चाहुचंती?
आउट करिया पे से कंडीशन टा कहूची.
ना.
आवल. Restricted गला मतलब subject matter accept.
आपण से 200 लोगों को चांदा रे चलंतु. तापर आपनकर आ गोटे प्रॉब्लम कोन हिची कहले? You cannot tell the court जे आज्ञा सब थर 200 लोग आछन जे थरे पैसा देले आ दउ नांती. आपनकर 200 लोग each time.
Practical
आपण सब दिन कले 365 into 200. आपण सब दिन सकाळे संजे रे दीटा शिफ्ट करिवे.
हेई करूनी.
सेरा त आपण इंडिविजुअल अपलोड समस्त कोन आपण भलिया केस सॉरी 50 item 50 51 50 for admission जेतो आरंभ हल त के नाहंती को आपण एडा कोन आपण स्पेसिफिक अर्जन थिला स्पेसिफिक तले 50 पेज 6 आपण से डाकंतु सेवन से लिस्ट कॉल करंतु पेज 6 स्पेसिफिक मेंशन 51 anyone present in page 6 51 आपण
59
नहीं सर सेटा पेज 7 थिवो 6 जोड़ा मेंशन है से कॉल करछंती जस्ट वेट काइंडली वेट 53 Mr. M.S.Sahoo on behalf of NP Parija for the petitioner opposite party blank. The learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions as paid for list on 18th December 2023. 55 Mr. Niranjan Singh for the petitioner opposite party blank. The learned counsel for the petitioner seeks accommodation to obtain instructions as paid for list on 15/12/2023 to grant further opportunity. So both likhi debe to grant further opportunity. Page 7 58 to 72
item 59
Mr. D.R. Behera for the petitioner. Mr. Opposite party blank. Yes, what do you want, sir?
2 weeks time for taking instruction.
The learned counsel for the petitioner seeks accommodation to obtain instructions and advance arguments as paid for after vacation.
Yes.
After vacation नहीं जानते. List on 10/1/2024. Then 60 state.
Pardon, my lord, my item no 56.
अच्छा आपण सॉरी आपण मिस कले ता माने पेज 6 रे थिला सेटा सेठी लिस्ट देई नांती की your name sir
S Palai
Mr. S Palai on behalf of Mr. S Bhagat for the petitioner opposite party 56 who is there OP1 state.
In the meantime the sole accused has died.
Appearance to note करे चेष्टा कर. I have to note the appearance in the order. 56 Mr. Mahapatra, you are there? Mr. S.S. Mahapatra for OP1. OP2 blank chat diyantu. The learned counsel for the petitioner on instruction submits that during pendency of the petition, unfortunately the petitioner has passed away. Memo te diyantu. the memo dated 23/11/2023.
P number 2, my lord.
Okay. The sole opposite the private opposite party number 2 has passed away. पुणे काटिବାକୁ ପଡିବ ପୁରା କାଟି ଲେଖନ୍ତୁ author. The learned counsel for the petitioner submits that during pendency of the petition, unfortunately, the opposite party number 2, private opposite party number 2 has passed away. Accordingly, the petitioner the petition abates and stands disposed of. Memo dated 23/11/2023 is taken on record. Yes.
Mention Lordship, it's item number 57.
57?
Yes, Lordship. Lordship, item number 57, Lordship on previous date obtained the instruction. Lordship, we already intimate him, but yet not to be instruction to be sought. So, Lordship.
Your name, sir?
Lordship, I am appearing on behalf of Mr. Dayananda Mahapatra. There.
57 तो नाहंती जे से बहुत जण अछंती आपनकर केतेटा मैटर अछि
एथरे चारोटी अछि 37 38 39 40 लास्ट
लिख तले इंडिविजुअली कॉल करे पड़िबो डाकंत 57 आइटम सब आइटम 1 then 2 3 4
37
5 तो 4 रे 1 to सब आइटम 1 to 4 लिखिबे नॉन फॉर पिटिशनर
I put 4 5 6 7
to grant further opportunity list on non appears for the petitioner when the matter is called opposite party blank छाड़ देबे serially mu डाकुची आपण 98 डाकुची to grant further opportunity list on
no
कि आपण थर्ड वीक रे दोनांती कि आसु नांती 17 16 जोटा देबे दियंतु 16 कहउछंती तो 16 1 23 16 1 24 then the second sub item same order, third same order, fourth also same order. Then CRL LP 37 of 2015. Upon go na sir?
Chinmoy Ponda, I am appearing on behalf of Mr. Mahapatra.
Mr. Chinmoy Ponda on behalf of Dayananda Mahapatra for the petitioner. Mr. Ranjan Raut is there. Anyone from his chamber? Uppi none. Blank rakhi diyantu. The learned counsel for the petitioner submits that despite his efforts to contact the petitioner has not responded and he may be accommodated further. As prayed for list on 9 के कहले ने केबे 16 के as prayed for list on 16 के 38 same order.
Yes.
39 same order
and
40 same order. Dayananda Mahapatra mark करछन्ते आपण कि जानुछि तला आपण बुझ परछन्ती तो yes
May it please your lordship. Your lordship, I am appearing on behalf of Advocate Subhasis Patnaik.
Sir, which item?
Item number 64, your lordship.
64 आमे जाइनु सिटी. Since actually he mentioned again, we went back to page 6. Perhaps he missed the liye. But page 7 डाकंत.
Page 7.
DR 59 गला ना. So DR बेहरा 59 देखिले. 60 state. आपण 60 जन डाकी देथिले.
60
state. 60 state who is appearing.
I am appearing. I'm so sorry.
60 is your file or Mr. Sangram Das?
My file. This is a leave to appeal, my lords, against the judgment dated 17/5/2016.
Mr. Devasis Naik, AGA for the state. Mr. Sahoo, DJ Sahoo is not there. Yes.
My lords, this is a leave to appeal against the judgment dated 17/5/2016, by which the accused was acquitted under sections 451, 341, 354 IPC and section 8 of the POXO Act. My lords, may kindly come to internal page 7, paragraph 14 of the judgment. The deposition has been discussed. I have gone through the deposition. This unfortunately, my lords, will suffer the same fate as the earlier ones. My lords, perhaps the microphone is off.
The petition under section 378 into bracket 1 and 3 of the CRPC has been filed seeking leave to appeal against the judgment dated 17/5/2016 passed by the learned special judge Baleswar in special case number 177 of 2013. What are some dekhi lekhi paribe? Dekhi lekhi better can analyze numerical bhulbal hai jay. And slash number is arising out of Bhogarai PS case number so and so, that is 159 of 2013. Acquitting the opposite party from the offences under section so and so so and so. Purata lekhile. The learned AGA, referring to the grounds stated in the petition, sought for indulgence of this court to grant leave to appeal. And also stated that the learned trial court did not appreciate the evidence rendered by evidence adduced by PWs 7 and 8 as well as other grandmother hele PW 4.
My lords.
Or co lectuandi PWs 7 and 8 who are co-villagers. Medical evidence se kichi nahi.
This is a case of assault.
Yes, it is assault, but still any injury, anything?
No injury, nothing has been else. And the accused.
And also in the proper perspective, कौन लिख ले sentence टा भूल गया कौन लिख ले sentence टा आउटर पढ़ो. Referring to the ground stated in the petition. Yes. To grant leave to appeal na to leave कौन? And also did not appreciate the evidence correctly of the other PWs such as PW2 informant, PW3 victim, and PW4 grandmother of the victim, and PW5 and 6 who are the aunt of the victim. To consider the submissions of the learned AGA, this court has gone through the copy of the judgment annexed to the petition rendered by the learned trial court. The learned AGA was also requested to point out any discrepancy from the copies of the depositions which is having, as has been recorded by the learned trial court. The learned AGA fairly submitted that the recording of the evidence, the deposition lekhantu, katik lekhantu, the deposition reflected in the judgment are correct reproduction that is contained in the copies of the deposition, and for the said reasons, nothing has been stated in the petition seeking leave to appeal. That the learned court has recorded any wrong statement in the judgment. Para. After going through the judgment, it is it is evident that after going through the judgment, it is evident that the learned court has noted contradiction in the evidence adduced by the persons who were presented as eyewitnesses particularly PW4 mother of the victim and PW5 grandmother of the victim. PW4 grandmother, PW3 is the PW4 grandmother. Yeah, the informant is the mother or the father? PW2?
The informant is one of the aunts.
PW4 grandmother of the victim and
My lords,
PWs 5 and 6. PWs 5 and 6 who are aunts of the victim. Yeah, the victim has been disbelieved also.
My lords, victim has been disbelieved also.
The learned court has also, to a certain extent, disbelieved the statement of the victim as PW2. Para. In view of the above, in contrary opinion of this court, the prayer for leave to appeal cannot be granted and the petition stands disposed of.
Hello, the victim is PW3.
Victim to PW3 kar diyantu.
Again, mother is PW2 informant.
3 karchanti dahan. Yes. So first time I dictated 3, then I have changed to 2. So he has correctly. Yes, next.
64.
From 60 to 64, anyone there?
Yeah,
61.
61. Mr. Pal?
Yes, my lord.
Mr. Amlan Shakti Paul for the petitioner. Mr. Devasis Naik, AGA for the state, opposite party.
I am for the opposite to mirror.
Mr. Gopinath Sethi for the OP number 2. OP1 AGA, OP2 Mr. Gopinath Sethi. Yes.
My lord, I pray for my lord some time, my lord.
Earlier
date, my lord, the learned counsel for the appearing for the petitioner has withdrawn his power, and recently I have given the power. And
the learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions from the petitioner and to advance arguments as prayed for. List in January after vacation.
Yes.
List on 22/1/23/24. So Sethi, you also obtain instruction.
My lord.
But ଆପଣ contact ରେ ଅଛନ୍ତି?
Again.
Mr. S. Udgata, 62, Mr. S. Udgata for the petitioner.
Yes, sir.
Opposite party blank. Yes, Mr. Udgata.
Yes, your lordship may kindly take up the matter.
Yes.
Yes. Hello,
Opposite party nahanti ki. Apon opposite party ki. Eta kon 138.
Again, 138.
Kon athre kon challenge korchundi conviction na acquittal challenge korchundi.
Acquittal. Against the acquittal.
Yes.
On the lower court has dismissed the case acquitted on 2 grounds.
এটা এটা ଆପଣଙ୍କର appeal ଟା ଯିବନି କି SDJM order against ଆପଣ state high court ଆସିବେ
ଆଜ୍ଞା
କାହିଁକି ତ ଅନ୍ୟମାନେ କାହିଁ ଯାଉଛନ୍ତି ସେସନ୍ସ କୋର୍ଟ କୁ
378 for against
high court
ଆଜ୍ଞା nomenclature ଅଛି appeal under 374
ନାଇଁ ସେଟା ତ ଆପଣ CRPC କହୁଛନ୍ତି but this order is the appeal lies to high court or not ସେଟା that is the question I'm asking you
against the acquittal against SC
ସେଠି ବି ତ ଲିଭ୍ ହବ it doesn't lie ଏଟା staff reporting ହେଇନି ଆପଣ complainant
I am not complainant
Yes, what is there you are saying?
Well, the
Mr. Mahapatra, against the order of the SDJM, Mr. S.S. Mahapatra, yes, order of the SDJM, appeal doesn't lie to Sessions Court.
Yes, ma'am.
Then how the High Court has entertained?
Which matter?
138 NI Act? Because every day there are matters where...
138 conviction.
Acquittal against a complainant actually. Sorry? Sorry.
Session size
Exactly. A lack of jurisdiction is you. Mr. Udgata, every day these cases are listed.
Yes, ma'am.
Many of the these CRLP they are from 138. What examine କରନ୍ତୁ ଆପଣ ଏଟା ଯୋଟା ଫାଇଲ କଲେ
ଆଜ୍ଞା
377
ହଁ କଣ ସେଥିରେ ତ ସେ ପ୍ରୋଭିଜନ ଅଛି ସେଠିକି ଯିବା ପାଇଁ
yes
इवन एनहांसमेंट टा भी वर्तमान अमेंडमेंट ହେଇକି ହେଇଗଲା सेशंस कोर्ट
yes
2005 ରୁ ସେ ପାୱାରଟା ବି ହାଇକୋର୍ଟ on 378 to the court of session from an order of acquittal passed by a magistrate in respect of a cognizable and non-bailable offence.
Yes.
Again, 378 टा again देखो. If such an order of acquittal is passed by any case instituted upon the complainant, the High Court or an application made to it, the complainant in this way grant special leave.
ପୁରାଟା ପଢିବେ ନା ଆପଣ
ଆଜ୍ଞା
ପଢିଲା ବେଳେ ତାକୁ ୱାର୍ଡ ଗୁଡାକ ମିଶେଇ ଦଉଛନ୍ତି.
If such an order, clause 4 ଟା 378 if such an order of
ଆରେ ଆପଣ ବାକି ଗୁଡାକ ତ ଉପର ଗୁଡାକ ପଢିବେନି କି?
ଆଜ୍ଞା ନାଇଁ ମୁଁ ଏଟା ହଠାତ୍
What is this? ହଠାତ୍ କାଇଁ ଆପଣ 378 ଆରମ୍ଭ କରିବେ ନା ଆଉ ଆପଣ ସିଧା କଣ ପେଜ ଉଲଟେଇ ପଳେଇଲେଣି?
ଆଜ୍ଞା ଆଜ୍ଞା 378 appeal in case of acquittal.
ହଁ
ତା କ୍ଲଜ 4 ଟା ଆଜ୍ଞା
କଣ ଆପଣଙ୍କ ମାନେ ଛପା ହେଇନି ବହି ନା କଣ ବେଶୀ କଣ ମୁଁ ବୁଝିପାରୁନି କଣ 378 ପଢୁନାହାନ୍ତି କାହିଁକି ଯଦି ପଢୁଛନ୍ତି ସିରିୟସ୍ अबाउट
378 appeal again in case of acquittal ତାପରେ ଏ ରେ ଦେଇଛି the district magistrate may in case of direct the public prosecutor ଆଜ୍ଞା
କଣ ଆପଣ କୁଆଡେ ପଢୁଛନ୍ତି 370 ଆପଣ କଣ ମାନେ ବହି ଲିପି ଯାଇଛି ନା କଣ save as otherwise provided ଟା କିଏ ପଢିବ
ଆଜ୍ଞା 378 in appeal in case of acquittal 1 ରେ save as otherwise provided in subsection 2 and subject to the provision of subsection 3 and 5 तापरे ए रे देला the district magistrate may in case direct the public prosecutor to present an appeal to the court of session from an order of acquittal passed by the magistrate in respect of cognizable and non-bailable offence. तापर बी रे लिखला the state government may in any case direct the public prosecutor to present an appeal to the High Court from an original or appellate order of an acquittal passed by any court other than a High Court, not being an order under clause A or on an order of acquittal passed by the Court of Session in revision. Then if is such an order of acquittal passed in any case which offense has been investigated by the Delhi Special Police Establishment constituted under Delhi Special Police Establishment Act.
सेटा सीबीआई
आज्ञा सेटा सीबीआई टा
तापरे
A टा to the Court of Session from an order of acquittal passed by a magistrate in respect of cognizable and non-cognizable offense, non-bailable offense.
So एटा कोन हम अरे आपण को कोलिग माने डे इन डे आउट एटा तो फाइल करछंती एवरी डे इट इज देयर
ना मु को जी 4 टा क्लॉज 4 टा एप्लीकेबल
4 टा छाडी की आपण 4 टा को डिसजॉइंटली पढ देले आपण तन बी टा पढले बुझी परिबे
the High Court from an original or appellate
to the High Court from no to the High Court
to the High Court from an original or appellate
slowly सेटी पढंतु original or appellate order of an acquittal
appellate order of an acquittal passed by any court other than a High Court
सरला सो आपणकर होची order of acquittal passed by a magistrate
आगे
सेटा कोठी हाई कोर्ट रे बोले कोठी पाइले आपण
आगे से similar order pass
138 तो के भी आसु नांती
किंतु
today at least I have dealt with 2-3 cases. Mr. Swarup Patnaik's case was there the other day.
मु को जी क्लॉज 4 टा आगे एप्लीकेबल हबो मो केस पे
केमिति एप्लीकेबल हबो ताले मजिस्ट्रेट को कथा की बुझिबो सुप्रीम कोर्ट जीवे ना कोन तापरे कहबे मु बुझ पाउन आपण तो देयर इज अ प्रॉब्लम ऑफ जुरिसडिक्शन मिस्टर दिस इज नॉट दैट एते हल्का भाबरे ग्रहण कले केमति हो जिंसटा को से आई डोंट हैव अ जुरिसडिक्शन टू एंटरटेन सच अपील
आगे
सेटा नहीं मु जानि नि सेटा आपण जदी
ताले मते आ गोटे तीन दियन
नोटिस हिच मु बुझी पाउनी तापरे डे इन डे आउट नॉन ऑफ द लॉयर्स आर माने फाइलिंग एनी केस इन बिफोर हाई कोर्ट समस्त को कोर्ट जाउची almost every day there are cases petitions are the appeal is filed before the sessions court fresh matter रे आज भी थिला first order of conviction second order acquittal against आपण हाई कोर्ट आसीबे and that will be LP that's not also criminal division LP हला परे allow हला परे तापरे करिवे पण 377 देखंतु just to draw a parallel 377 मानुचे आपण parallel
appeal by state government against the sentence
yes
1 save as otherwise provided in subsection 2 the state government may in any case of conviction on a trial held by any court other than a high court direct public prosecutor to present an appeal against the sentence on the ground of its inadequacy.
So जतो inadequacy होची आपणकर appeal रे this was earlier to high court पण amendment ना मार्क करंतु it is from 23/6/2006 नो substantive offense रे भी आपणकर enhancement पई sessions court वर्तमान original jurisdiction So Mahapatra, you may examine, but what he's not saying that what complaint is used, maybe that is the confusion.
Yes.
But in all cases, in all cases, they are filing. Yes, next. कौन लिखले? Mr. S. Udgata for the petitioner, opposite party blank. The learned counsel for the petitioner seeks accommodation to advance arguments. January, December. As prayed for list in on 12/12, 12th of December.
64, 63,
अब जहां जो मैटर टा मेंशन कर देबे जदी करिवे नहले मु कॉल करिवेनी 4:30 पर लिस्ट विल नॉट बी कॉल्ड आपनकर जोटा पार्ट हार्ट थिला सेटा कहउचंदी अच्छा तले नो मैटर इज कॉल्ड आफ्टर 4:30 ओनली मेंशन के करिथिबे जदी ताले आपण स्टेट मेंशन को जात 75 Mr. P.K. Malik on behalf of B.S. Daspurida for the petitioner. 75, you are there, Mr. Mahapatra.
My friend.
Mr. Devasys Naik, AGA for the state. Learned counsel for the petitioner seeks accommodation to obtain instructions and advance arguments as prayed for list on 19/12/2023. Thank you.